All right, here we go. We'll resume with our hearings. So Senator Hayes, you're up. All right, apologies for the delay and the technical difficulties here. This is Senator Hayes with Senate Bill 424.
What's that? Not. You'll be getting no jokes out of me, but I sure feel welcome here in JPR. Good afternoon, Mr. Chairman, members of Judicial Proceedings Committee, Senator Antonio Hayes for the record. After my testimony, I'll be followed by Bill Costelli, representing the Maryland Realtors, who will speak to the need for this legislation. Current law does not protect potential real estate buyers' trust money when purchasers fail to proceed. Section 10802 of Article Real Property allows the broker to distribute the trust money at will. As this assembly seeks to create new legislation to ensure equitable opportunity for property ownership, Senate Bill 424 can encourage hesitant buyers to invest in property and rectify some of Maryland's discriminatory history with respect to real estate transactions. When a real estate transaction falls apart, disputes can arise over who should receive the deposit money. Those funds can be held up for long periods of time, preventing buyers from moving forward with another transaction. Senate Bill 424 will automatically return deposit funds to the buyer if they have exercised certain contingencies in a contract. This will reduce conflict between buyer and sellers by absolving the trust money holder of any liability and decisions related to distribution of funds. If there are legitimate disputes between the buyers and sellers, it can still be settled in the courts. New buyers whose trust money is unreturned after transaction cancellation not only lose one real estate property, but may also be unable to invest in another. The state must reduce these types of barriers so community members from lower socioeconomic status have the opportunity to own real estate. Thus, I urge a favorable report for Senate Bill 424.
Excellent. Thank you very much, Senator Hayes. And seeing no questions, we'll move on to your panel.
Yeah, I'll wait for.
Excellent. Mr. Costelli.
Thank you, Mr. Chair, members of the committee. Bill Castelli with the Maryland Realtors. We want to thank Senator Hayes for introducing the legislation. And the bill really is seeking to return deposit monies in cases where there might be a dispute between a buyer and a seller, but typically it is the result of a contingency that the buyer exercises in the contract. And what ends up happening is, right now under Maryland law, a seller must sign to release that deposit money. So if a buyer has exercised the contingency because the property did not appraise, they don't have enough cash for the difference between what their loan is going to be and what the price that they've offered on the property, then there's appraisal contingency. They can step out of the contract. They're not on the hook for trying to figure out where they're going to come up with all that cash. There are inspection contingencies and all kinds of other contingencies, some dictated by law, not just the contract. So if the buyer exercises that because they didn't get HOA documents, theoretically, they should get their deposit money back and be able to move on with a different transaction. But I will tell you what happens is many times a seller will become upset about the fact that the transaction didn't proceed. They won't sign off on the release of deposit monies, and this money can not only prevent that buyer from seeking another property right away until they save enough cash money to move forward for another deposit, but it can remain in real estate accounts for years. I have one broker who got taken to court 10 years, the buyer seeking to get that deposit money back, and there was nothing he could do. The law didn't prevent him from doing it. This bill would effectively open that up so that in certain contingencies where it's very clear that the buyer exercised an appropriate contingency, they would be able to get that money back, and then this money just doesn't sit in these accounts that no one can access. And it can sit there forever.
Thank you very much, Mr. Costelli. Turning to the committee for questions. All right, excellent. We have one from Senator West and then Senator Castley.
Hi. Thank you, Mr. Chair. Mr. Costelli, isn't it possible that the seller, under this circumstance, would suffer some damages. For example, if the seller's taken the property off the market for 3 months, pending the settlement, and then the buyer walks away days before the settlement, suppose the contract between the buyer and the seller contains a provision providing for payment of damages to the seller. Under this bill, would that money still be payable to the seller, or would the seller not be able to receive the money that he contractually provided that he was permitted to get?
So sometimes the damages are confused with the deposit, and they are not, deposit is not essentially liquefied damages there for the seller to access. But, so in that case, yes, the seller, whatever clauses in the contract for liquefied damages would still matter. And I will tell you, Pennsylvania actually takes this approach, the approach that's being proposed in this bill. And you do occasionally have a seller that might be concerned about it. They would have the opportunity to go to court. It almost flips the way, Pennsylvania kind of works in a almost exact opposite way that Maryland does, where it would typically be the buyer having to initiate it. In Pennsylvania, it's normally the seller that would initiate that.
So if the contractual agreement between the buyer and the seller provided that some of that deposit money would be payable to the seller under certain conditions, this bill would not interfere with that contractual term?
Correct. It's just dealing with whatever earnest money that they've put. Now, a lot of times, sellers think about that earnest money as a liquefied damage to them, but it's not. And if the buyer is deemed to have exercised their legal right to step out of the contract, they really should get that money back. And many times it's just held up for years.
Okay, great, thank you.
So what is the purpose, in your view, of the deposit, these deposits? Why are they paid at all?
So there is no requirement under Maryland law for there to be a deposit, but
I understand it's
often,
a contract. The contract
Yeah.
requires it, right?
well, yeah, so sometimes even the contracts don't, but it will depend. I mean, a lot of times a buyer will want to show good faith to a seller, have their offer, particularly in a very active market like we have, if they want to draw attention to their offer, maybe they'll provide a bigger deposit over some of the other deposits. So it shows some good faith. It shows definitely a willingness to move forward with the transaction and sometimes separate themselves from other people making offers on the property.
I've never seen a real estate contract that didn't require a deposit of some amount and is paid pursuant to the contract, and the payment and the return is controlled by the terms of the contract, right?
Yes, if the deposit language is in the contract, that would be controlling.
Have you seen deposits paid that aren't controlled by the contract?
No, I
Yeah.
haven't.
I mean, it's absolutely the standard in Maryland, a real estate contract, that the deposit, the payment of the deposit, the amount of the deposit, how it's held, how it's repaid, under what terms it's repaid, is all controlled by the contract, right?
Well, it's controlled by the contract to the point where the seller, then, let's say this a contingency arises.
Sure, but that's still controlled by the contract. Then a dispute arises as to whether, under the contract, the contingency has been satisfied or not satisfied. And now we're in a position where the buyer paid a deposit, and now the buyer says, hey, the contingency wasn't satisfied, you owe me back the deposit, and the seller is saying, wait a second, it's not been satisfied, and I'm not going to pay you back the deposit. And therein lies the dispute to be resolved, right?
Correct. But
Yeah.
a lot of but to give you another example, a lot of times what ends up happening is buyer is owed the money, and seller really doesn't have a legal leg to stand on, but they just don't sign the release form. And so it's a process issue too, where Maryland law, under the Brokerage Act, requires that release to be signed by the seller.
And are there any terms under the Brokerage Act or in the standard contract for resolving these matters when the seller just, without any reason, without any good faith reason, even plausible, refuses to sign?
So about maybe 12 years ago, it might even be longer than that, Maryland law was changed a little bit to provide a 30-day letter. so that a 30-day letter, but again, and in this case, that 30-day letter would basically say, I'm holding the escrow money, I deem that buyer exercised the appropriate contingency. I send a letter out, the 30-day letter, to both parties. If I never hear back from the seller and they don't object, I can then release that money. So you will see some brokerages use a 30-day letter. I will tell you, though, that if the seller objects and they put that in writing, the broker is again stopped, and which is why I would imagine in most real estate companies in Maryland, there are earnest monies that they have that they've never been able to return.
Right.
And to be honest with you, until that brokerage closes and it becomes abandoned property, no one is actually ever going to get that money.
Right, so it seems like we have a matter of extremes here. We have on the one case, we have brokerages and sellers who are just holding the money ad infinitum, and that's not a good thing. And on the other extreme, we have buyers who say, hey, as soon as I say it's satisfied, I should get the money back. Like, I say it's satisfied, boom, we're done. Now, of course, that buyer might be wrong. It's not satisfied. On the other hand, the seller sitting on the money for years and years isn't right either. So you're saying right now we're on the one extreme of we can't get it back at all, but then your solution seems to be to propose the other extreme, which says whenever the buyer says give it back, give it back. Don't we really belong in the middle here somewhere where there's, for example, a 30-day or 2-week requirement that the seller either give it up or assert good faith reasons why, and if there's a dispute, if you all want to force it in the standard language into an arbitration that has to be completed in 1 week or 2 weeks, isn't that where we really need to go here? Because you're coming with a problem that says the sellers are being extreme. The buyer solution is, okay, we'll be extreme, but I think most things that come in proper resolution take us to the middle ground. So it seems like this bill needs to be tailored to assert a middle ground, because I'm sympathetic to both sides.
Yeah, and I would mention that if you take a look at the language to start in the bill, where it defines contingency, this does not apply to all contingencies. Certainly, if you take a look at like financing contingencies, and we have some language that we proposed in an amendment, making it clearer that this is limited to the statutorily defined contingencies, those are the ones where it is pretty clear. You either got the document, you didn't. The property either appraised, it didn't. We don't include things like financing because I will tell you, there are a tremendous amount of gray areas between buyer responsibility and seller responsibility in the financing contingencies. So it doesn't include that because we do think there are gray areas that speak to the concern you have. And that's why, so we try to address a big part of those concerns by limiting it to these contingencies.
And I appreciate that. I'm looking at your list here. I could dispute whether your appraisal was in good faith or whether it was a hack appraisal and didn't really do a right job, or whether you actually cooperated in it. Building permits, fees, feasibility studies, again, you can dispute, the seller could always dispute whether they actually pursued that in earnest or whether it was a sham just to get out of the contract. Just pretty much most of this list could be abused as a subterfuge to get out of the contract. And from the seller's perspective, you agreed to the contract, now you're coming up with an excuse to get out of it and avoid the contract, which oftentimes means the seller will say, I'm not going to give you the deposit back until I get another contract. If the new contract meets or exceeds your contract, it all comes back. But if the new contract brings me 30 grand less, I'm not giving back your money. And to assert that that's not a liquidated damages, I'm not sure what a deposit's for if it's not as a partial offset of liquid damages and show a good faith. So anyway, all right, we'll take a look at it. But thank you very much.
Sure.
Thank you, Mr. Chair. I'm sorry for the second bite of the apple here, but I'm thinking if I were a broker and I had received such a deposit on a property, and then all of a sudden I had the seller and the buyer disputing who ought to get the money or how it should be paid, I think I would just interplead the money into court and let the buyer and the seller fight out in court who ought to get the money. I'm not sure why this money has sat there in the accounts for years unless the broker didn't have good counsel, because the easy answer is, I think, just interplead the money into a court, the local court of jurisdiction, and let the buyer and the seller fight it out in court and let the judge make the decision who gets the money. Why wouldn't that be an acceptable alternative to this bill?
It is an alternative, but I will tell you, and I think what this bill helps the most with are first-time buyers and other folks who are just trying to get into the market. Certainly, if there's a large deposit that has been made, you can interplay that before the court. But I will tell you that in cases where it's a smaller deposit, by the time attorneys are paid and everything else, there's almost no incentive for a buyer to even try and get that money back by going, once it goes to court. So the buyer may go back to the broker and say to the broker, well, sure, that helps you, but it's not helping me get my money back because now I'm going to court and I'm going to spend as much, in court fees and costs in terms of trying to get the $1,000 back or the $2,000 back.
Okay, thank you.
Thank you very much, Mr. Costelli. All right, next we have one more witness, Mr. Davis, Wayne Davis.
Good afternoon, Chairman Smith, Vice Chair, and members of Judicial Committee. I'm here actually in support of Senate Bill 424, Real Estate Brokerage Services, and just to piggyback off of what Mr. Costelli was just talking about, I'm going to give you a real-life situation that I just had at my brokerage with one of my agents. I'm actually the broker of United Real Estate Executives. I've been in the real estate industry for 26 years. So what we find, I'm going to give you this example. We had a couple, first-time buyers in their 60s. They were purchasing a home, which was, I'm going to say it was probably a flip property. It was an investor that owned the property. We did a home inspection. The property needed a new roof. They did some patchwork on the roof. The roof needed to be completely redone. So the buyers, because they're first-time buyers, typically they're a little nervous or hesitant about moving forward. They never had a big expense like this. So they decided they did not want the property anymore. So as a negotiator, what we try to do is, we try to make the situations work. So what we did is we asked the seller to escrow money for a roof. So we can get a roofer to come out, give an estimate, and if it was deemed that that was the issue, then the roof could be paid for. However, in this situation, the seller refused to do that and decided to keep the earnest money deposit. So the earnest money deposit was $2,000. These people were on a fixed income. They were going through a program. They didn't have any additional money to go out and find another property. They were at the end of their lease. Everything was just, falling apart on their end. So the seller went ahead, put the property back on the market, went under contract, settled. I just got their $2,000 back probably like 3 weeks ago, and that was from 3 months ago. So what we're saying is that a lot of times these sellers will hold the deposit hostage just because they're upset or they're mad. And that's what we're running into. Now, it's not, a thing where they're trying to just blatantly get out. It has to be a legitimate reason. And typically we find that it's when there's some sort of repair issue or, something like under appraisal or things like that, especially in this market.
All right, thank you very much, Mr. Davis.
Thank you.
All right, and with that, that'll conclude the testimony and the hearing for Senate Bill 424. We'll now move on to Senate Bill 678 with Senator Hayes.
All right. Good afternoon again, Mr. Chairman, members of JPR, Senator Antonio Hayes. For the record, I'm pleased to be speaking with you today in support of Senate Bill 678, which allows a buyer to mask their identity when entering into a contract or sale for a single-family residential real property that is executed with the services of a real estate broker. This bill was heard in this committee last year, and we've made several adjustments to the legislation. One of them addressing uniform application. During the 2021 regular session, there was a concern that the bill was to permit buyers to be able to elect whether or not to be identified on a residential contract or sale. The intent of the bill is for the name of the buyer to be prohibited so that the bill will be applied uniformly and consistently for all buyers on residential contracts of sale. Removal of the buyer's name fields from the residential contract or sale and associated addenda also specifies the application, which under the original bill supported using a moniker like Client A or Client B. Essentially, the reason why we're bringing this bill to you is oftentimes there are situations, and you'll hear from some folks that's actually practitioners, whereas people are discriminated against because of whatever cultural, ethical names that they may have, and in their attempt to purchase real estate. Also, in 2021, the Attorney General's office stated that they were concerned over entity purchases. The amended bill specifically states the bill is for residential home buyers and will not apply to commercial or investment purchases, nor for purchases by entities. The bill has also been amended by editing buyer to home buyer to more effectively detail the intent of those who seek to protect. Contract validity. During the 2021 session, there was assumptions that offers to purchase would not contain necessary initials or signatures. The amended bill contained language to allay these concerns. The residential contract for sale, though not containing the name of the home buyer, will contain the necessary initials and signatures to support a valid contract once executed by seller. Lastly, in the 2021 session, there were questions about whether there might be fraud by a buyer who was not intended in the contract of sale. We provided a statement in 2022 amendment that the buyer would execute a document with the buyer's broker. An exclusive buyer agency document would support this. In the event there is underrepresented buyer, a document verifying identity will require. Lastly, there was a amendment that was submitted on behalf of my office. It simply adds a preamble clause, and pretty much, as I said previously, the purpose of Senate Bill 678 is to protect people from discrimination in real estate transactions. It will also modernize the fair housing laws that are already in place. The removal of a buyer's name in the real estate action protects people against discrimination. Soon you will hear come up on my panel Rodney Dotson as well as Kimberly Kepnitz, who brought this piece of legislation for me as they are practitioners in the field of real estate and have a strong interest in making sure that their customers or clients aren't discriminated against. And with that, I urge a favorable report for Senate Bill 678.
Thank you very much, Senator. All right, we'll bring up your panel next if there are no questions. So if we could have Rodney Dotson, Kimberly Kepness, Mr. Murray, and then those are the proponents.
Good afternoon, Chairman, Vice Chair, Senators. My name is Rodney Dotson. I'm currently a realtor, real estate professional with Monument Sotheby's International Realty, lifelong resident of the 7th District in Baltimore City. As my good teachers in Ashburton Elementary School told me at a very young age, start with the main idea. The main idea of this bill is that it's twofold. We have a problem and we have a solution. So the problem is information on a potential buyer is more readily available than ever before, specifically a buyer's name. A seller knowing a buyer's name initially can provide insight into his or her race, national origin, sex, familial status, in which, in this case, a buyer would not be protected against possible discrimination. A buyer's privacy is protected. So the solution is we contend that we should remove the buyer's name during the initial negotiation process. As it stands now, we, as realtors, present a seller with a contract, the actual contract, which has the buyer's name and the seller's name and a list of other terms. In the field, as I'm working today, I thoroughly and readily see in this so-called hot market, a seller being inundated with several offers to choose from. In that case, they have the terms and they have the buyer's names. I would say not it's not said, but it could be implicit bias that your contract, if you were a buyer, would not be accepted. This is a simple bill to further fair housing for Maryland and the United States of America. Thank you. Any questions? Oh, sorry.
Good afternoon, Chairman, Vice Chairman, Honorable Senators. My name is Kimberly Kepnes. I'm with Monument Sotheby's International Realty. I think we're here today to talk about whether the current fair housing laws are enough to protect buyers when they're negotiating with sellers. The current law, we don't believe, adequately addresses innovation in our industry. In the 30 years that I have been a realtor, one of the most common occurrences with sellers is the information they have been able to uncover about buyers. Most start with pride about everything they've been able to find out. It starts with the name, and sometimes the name is not familiar at all. It continues, and one of the biggest innovations that we've had is Google. And pretty soon, Google uncovers many other criteria about the buyer that has no basis in the contract of sale and a negotiation between the parties. It has been a common practice for realtors to even drive the conversation with love letters, where we go into great lengths about the emotional appeal for our buyer clients. Maryland Realtors last year, as of October 1st, prohibited love letters from being provided between clients. That is a protection for implicit bias so that parties don't utilize things that they're not aware of. Implicit bias is that feeling, that sense that there's something about a party we don't want to deal with, we don't want to work with. It's important for us to understand that the current law was in place before these innovations. And today we need to bring this law to date to adequately protect buyers from sellers who might discriminate, implicit or otherwise, and protect sellers from the unconscious bias that they have once they know a name and uncover more information about the name. Thank you.
Chairman, members of the committee, my name is Rory Murray here on behalf of the Maryland DC Credit Union Association. First, it's nice to be back here for the first time in like 3 years. A little weird, but here we are. When this bill came up last year, we opposed it. We thought it was a little ambiguous. However, I've had a lot of conversations with the folks at Sotheby's, and it seems like they've uncovered a legitimate possible gap in housing protection for their clients, one that I didn't think of before, but the names on these bid and offer documents could be used against somebody. And I've listened to the stories, and some of them were, they were egregious. It wasn't, I told Rodney earlier, it wasn't something I'd ever thought of until they brought it up, but it made complete sense when they started saying how it happens in practice. Our, credit unions as a whole oppose any forms of discrimination in housing, and we, as member cooperatives, we do anything we can to help our members get where they want to be in life. So we think this is a reasonable step forward. Our main issue last year, as I said earlier, was ambiguity in the language. We wanted to ensure that any lending documents would have all of the required information from day one. And the folks from Sotheby's and Senator Hayes and his staff were nice enough to give me their time, listen to our concerns, make amendments, and we are in full support of this bill. As I said, I think to their credit, they've identified a gap, and we think this is a good step forward. Thank you.
Excellent. Thank you very much, Mr. Rory. I saw Senator Watson, and then Senator Carter, and then Senator West, and then Senator Castley.
Thank you, Mr. Chair. So this bill is literally all about the buyer's willingness to sell to a specific individual, right? Without knowing who that individual is up front.
Let's dissect that just a little bit. Could you repeat it?
the buyer's willingness to sell a home.
Okay, let's say, so buyers buy homes, because selling
I'm sorry,
kind of,
the seller's willingness to sell a home without knowing specifically who the buyer is, right?
initially.
Now, but this does not impact the qualification of the buyer with a bank or whatever, right?
No, it does not.
And so at what point does the buyer's full name and everything become public knowledge, like in SDAT?
We contend that when all terms are agreed upon, and Kim can kind of speak to this as well, that at first practically the contract is initial.
Yeah.
So you can't tell a person's identity from initials, but it does validate the contract moving forward. When all terms are agreed upon, right now, currently, to ratify a contract, to make it valid, the date of ratification is put on the last page of the contract of sale. We contend that at that time, 24 hours upon the ratification, the contract will be made whole and the buyer's name would go on there. So moving forward,
Got it.
all entities such as lenders, title companies, everyone has the contract. But in the beginning, the negotiation phase, name is not a factor of acceptance.
So sometimes I'll look at on the weekend a show called Flip My House.
Yes,
right?
sir, I do.
All
too.
right, and in Flip My House, it's always a kick out of the sellers wanting to feel this connection with the buyer. Somebody is going to just take such great care of it and treat it like they did when I did it. And there's that personal meeting with the buyer and the seller. And so, you know, through this process, there is no face-to-face meeting with the buyer and the seller. Is that fair?
Not initially, but that is fair, because we're saying initially, we want to shield, change is hard. We've been doing things a certain way, but it's time, as technology changes, we have to change.
So they wouldn't see each other physically until closing.
That's typically what happens nowadays,
Okay,
but they wouldn't see the name initially.
okay. Thank you very much. Appreciate
No
you.
problem.
I like that show. It's a good show. All right, so we'll go to Senator Carter.
Thanks, Mr. Chair. Thanks, Senator Hayes, for bringing the bill. Thank you to the panel of support. So we've had this bill last year, and I remember it really well because it was the first time I'd heard of it, the concept, and I was wondering if it was done at other places, and I do believe that you said it was. And so I initially struggled with the concept because it's almost like we are acquiescing to the fact that we anticipate there will be racism, and we're seeking to find ways to accommodate it. And that is something that I just struggle with, like philosophically, it's problematic for me. But I also brought this very next issue up last time, which was that my experience is the absolute opposite. Some years ago, when I went to sell my condo unit, I would happen to be the first and only black person, also young person, who lived in the building. It just was just traditionally like just an old, a building that, older people gravitated toward. There were no children in the building, and I was, again, the first and only black. And then when I went to sell the place, I was advised, take all your pictures down, take everything that could make anyone possibly think that you could be anything other than a white person. And I felt this the opposite way. I felt, that a buyer could possibly discriminate or not want to buy a place from a black person. And so I'm wondering why, one, we restrict this to single-family homes, and then number two, why it isn't both ways.
I'm gonna defer to one of the panelists, but I'm assuming when you said old people, you was referencing more seasoned people. Right?
Older.
Thank you for the question, and I do recall our meeting last year, and I appreciate your experience. And I can say that We're here today because we don't think the present law does enough to protect us from ourselves and from the feelings and the actions that drive from our experiences. And I don't disagree that there will come more opportunities to further protect home sellers. It is necessary for transparency with sellers to be able to confirm that those sellers are the parties that have the legal right to sell a home. I don't disagree that this issue can also apply to home sellers. And with this bill, it provides another protection that recognizes innovation has changed our industry. And having access to more information has not provided benefits across our industry in this regard in terms of fair housing. So I agree with you. I think there are opportunities. I think we're starting with buyer protection so that we can do what we can while the parties are negotiating, that the names are not revealed, so that we can focus the parties on price and terms and not these other factors. It's the other factor that all of a sudden the highest price offer doesn't get accepted because there's just something the seller likes about that other buyer, this sense that they fit in better. We need to protect those buyers. Thank you.
Follow-up question. I know I asked the question before, 'cause the answer was that it does exist, but whether other states have a similar law that we can look to see an example of where it's already been in place and it's been effective.
And I think that was misunderstood. There isn't another state that presently has a protection of this kind. We did talk in the Senate hearing last year about the Massachusetts case where the realtor representing the seller had presented offer terms on a spreadsheet, and no names were included on the spreadsheet. And the offer that was agreed to, in theory, on the spreadsheet, price and terms acceptable to the seller, when the realtor went to meet with the seller in person with the physical contract, and the seller saw the name of the buyer's first name was Ebony. And the seller said, "Is that an African-American person?" And she said she would not sell to that client. And that this occurrence is something we brought to the Senate to give an example of how bias can impact someone's decision, and they might sell to someone for a lesser price and term because they like another buyer better. When it violates fair housing, action is necessary.
Thank you.
Thank
It's so
you.
interesting because I feel like I have the opposite situation, not just in the seller
I know.
standpoint. No, but my name is Jill, which is traditionally not associated with black people. So people would see Jill and make a different assumption, and they see me coming, and they're like, "Oh, nope, never mind." So,
Can I just add on to that, Jill? I think it's just as I was stating to Senator Watson, I think change is definitely needed. Bringing this bill forward and being a co-author to it, it brought some personal revelations to me. The names of my children, Stephen, Connor, and Ella, was strategically ambiguously decided upon between me and my wife, Shaquana Foster Dotson, whom, if I were to decide to put in a contract in a neighborhood such as Roland Park that I dreamed of living in one day, my name and my wife's name might be, racially discriminated upon. So it's just time, and that's just a personal, thought that came about. It's time that we remove the names in the negotiation part of it, and then Senator Joe, to your point, there are further advances being made in the realm of appraisals, and for sellers as well.
Just want to move this along. Go ahead. No, go ahead.
I was just going to say, if that did happen, though, you'd have some legal recourse, most likely, especially when you mentioned Roland Park, which was one of the last most stubborn neighborhoods in my district, sadly. No, that to remove racial covenants. They had it up until about, almost, about 15 years ago, I think. Thanks.
Some of them are still on the books in Montgomery County too, actually. Obviously not enforced, but, all right, Senator West.
Thank you, Mr. Chair. So I just want to give you a real-world example. Last summer, my wife and I were interested in buying a beach house down in Rehoboth, and the market was really hot. And we made an offer for one house, and there must have been 8 or 10 other people who were making offers, and we didn't get it. And we did the same with the second house, and we didn't get it. Finally, with the third house, the broker that we're working with said, it's not yet publicly listed. If you can come down right now and make your offer today, I might be able to get you in there before anybody else makes offers. And we got it. So, but that just goes to show that if somebody wants a house, they're going to do anything they can to get the house. So in that case, we hopped in the car, we drove down right there that day, we loved the house, we put the offer in that afternoon, and we got the house, because we wanted the house. So if this were to become law, and I really wanted a house, I'm sure I would work with my broker to, even though my name is not on the contract, and there's nothing about me in the contract, I'd work with my broker, and my broker would divulge all sorts of good information about me. And so all of a sudden, the seller has good information about this particular buyer and knows what my name is, et cetera. Everybody else is anonymous. My guess is I'm going to get the house. And once that gets abroad, brokers will be working with people who want to buy houses, and will say, look, you're an attractive couple. Here's what we can do to enhance your opportunity of buying this house. And so this bill may actually work to the detriment of the people who remain anonymous, because information about the other people is going to be available to the seller.
Well, and interestingly, I'll bring that was one of the points in 2021, was that the bill would not be uniformly administered. And
Well, there's
what
nothing
we're
in this,
saying
there's
is-
nothing in this bill that says that somebody can't, through a back channel, communicate information about them. All this says is the contract will contain an anonymous.
Well, and again, there is the law, there's the code, and there's the standard of practice. And so I would propose that as a licensed Realtor, the standard of practice is to protect the interest of my client. And so I'm going to do that. And we would expect that all Realtors would participate in the standard of practice. Maryland Realtors, in prohibiting the love letter, is precisely what we're talking about, is that the love letter does put clients, seller clients, in the position of potentially violating someone's rights. And so in the standard of practice, Maryland Realtor says it's not appropriate for us as Realtors to promote our buyer clients, or to try to accentuate or try to in some way emote a different behavior from the seller client. And so while I congratulate you on your purchase, what I would propose is that you receive the house because you didn't compete with other buyer clients, not because your Realtor gave information about you.
Well, maybe I should have waited in that case till it was publicly listed and just taken my chances with the other 12 purchasers.
Well, and again, that's a separate issue, is that in terms of fair housing, it is a responsibility for licensees to equally provide housing as an opportunity, so that I have an equal opportunity to buy the house that you
Well,
had
let
the
me just ask
opportunity.
one follow-up question. So in this world, the brokers want their commission. They would love to sell the house and get the commission. So if I'm working with a particular broker, are you suggesting to me that that broker would not, if it was advantageous to make this sale, divulge information about me to the seller of the house in order to promote my buying the house and the broker getting the commission on the house?
I'm saying no, I'm saying absolutely not. I'm saying that as a licensee, I would expect all of my colleagues to uphold the law and the standard of practice.
Well,
And that's
there's
what makes
nothing,
us Realtors.
there's nothing in the law, is there, that says that a broker can't communicate information about the purchaser to the seller?
Well, there is, actually, Maryland, the Realtor Code of Ethics, in the Code of Ethics, it outlines that Realtors will keep confidential information about their clients.
Well, suppose the client says, I don't want it to be confidential.
And I can't answer that question. I can say that if it violates fair housing or it puts the client at a disadvantage in terms of fair housing, that would not be appropriate.
No, all right, well, thank you.
And perhaps I'm not answering effectively.
And
Excellent. All right, we're
I
gonna-
think you provided the information I wanted.
Thank you.
Thanks.
All right, we're going to move along. Senator Huff.
Just a question, because I remember, I find this bill fascinating, because 2 times we sold houses, to be honest, and every time we were bidding in on houses, it was the money that drove it, how much money they were putting down, how much was available. It was quite frankly the price. We were in a price war. I didn't care at all. I don't even remember the people's names. I was just looking at the price, what they were offering. I'm curious, as a real estate agent, is that not what people are doing from your personal experience or your clients? Are you saying your clients are making racial decisions versus looking at the price? Like,
We're saying that, that they could.
are you I'm sorry, I missed me. Are you a real estate agent?
Yes, sir.
You are. So are your clients doing that?
So I represent buyers and I represent sellers as well.
Okay.
I think more specifically to speak to your question, let me give an example. The genesis of this bill came through a meeting in our brokerage. There was a question. There was a realtor in our brokerage that had submitted a verbal offer to the seller, and her client, who was the buyer, their name was last name Abuku.
Mm-hmm.
All terms were agreed upon. The realtor sent over the contract, and there was a ghost. There was no answer. She tried several times getting an answer from the seller, just no answer. So it clicked in her head that, hey, this might be something racial because of their name. And the question was posed to the brokerage of what can be done about this. Me as an African-American male, I said, we don't have any power. We're powerless. We move on to the next house.
Well, with all due respect to that one example, if that's the only example, the example is you just gave, it may have been, but you don't know. So my question is, since all of you sell real estate, my only knowledge is when I bought and sold.
Yes.
To be honest, I looked at nothing other than what they were offering money-wise. And I always imagine most people are in that position. But you all deal with actual people buying and selling. So from your clients, are your clients doing this? Yes or no?
I think so is it inconceivable to...
No, not
believe-
inconceivable. Are your clients doing this? Yes or no?
I don't think any...
Based on, and if interested, we could certainly find the cases that have been filed in HUD, but there are cases, so the answer is yes.
Yes,
there
there's
are
always cases. Are your clients?
Yeah, there are
you're-
cases.
You came here to the committee today, asked for this
Yes.
bill. You're here in front of, as experts. Are your clients doing this?
I believe clients are doing this.
Are your clients?
I believe that I have had clients that I have questioned their decisions based along these lines.
So out of how many houses have you sold or been a part of that this has happened?
I've been a Realtor for almost 30 years.
Okay, and how many times has this happened?
I can't even quantify the number.
I just ask because, they say hard cases make bad law, and I want to make sure that
And
I'd like to know there's a problem in front of us that we're trying to solve. And I just go back to my own personal experiences because, we had a great speech last night too. I don't want to put blinders on if there's a problem. Because I look at it from, I like to think people make free market decisions of what's coming in as far as the price of homes. But I do think of a situation that when we were, I think, selling our first home, we actually had, we went in, had a contract, and then you put your money down on the contract to show it's a real thing. And then the guy ended up pulling out. He pulled out past the deadline, and it actually hurt us because we had a contract on another house, and we lost it. And I was really mad. I went to collect that money, and they go, no one ever gets that money. So I took him to court. He never showed up. And they were like, just let it go. You're never, when people do this, they just get away with it. It's too late. You lost out on the house. You lost all your money. But it would actually be good to know if people like that like, this guy keeps going around and doing that all the time. Like, you could see his name and other agents say, hey, this guy's actually been in court 4 different times for, like, making offers and pulling out on houses. So what do you do in those kind of cases where you have people who are in the system? There are buyers out there, like the guy that caused me problems, lost us a house, who take advantage of the system. Now, if I'm looking at a contract, I don't know that this guy is somebody that goes around basically making bad business deals and ripping people off, like happened to me.
Well, and.
Like, this guy
and
was brought to
having his name
court.
didn't stop that either.
Maryland case search would shows that I brought a case against him for breaking a contract and breaching our contract. A future seller would not know that this person had been in court for breaching contracts.
And there could certainly be provisions added to the code to address these kinds of, if there was an additional transparency requirement with the buyer's agent or with the real estate broker that's writing the contract, that's certainly something that could be addressed, because the identity is not unknown to the broker. The identity is not unknown to the lender. And I think the bill has to do with.
I would like to know if this person's got a case search record that's 20 things long of breaching contracts.
And we can have additional representation, so I think that we're willing to, and very
But why
interested
should
in
you
talking
know
about
that and
those.
I not know that? Why should you know that the person has 20 cases for breaching contracts and I not know that?
Senator, I'm not a real estate agent, and I think you admitted that you're not a real estate agent as well.
No, my father was one for his
one
whole
of the
life,
things-
though, so I am familiar with the
Okay,
industry.
we could sing at the same time, but we can't speak, so I'm gonna wait till you're finished in case there's a question.
I'm done.
All right, thank you so very much. So, I'm not sure if this is gonna solve all of the world's problems, right? But we know that there's implicit bias in our atmosphere, right? And people have those experiences. What these professionals have come to us today in trying to identify a remedy to get away from that. I know in my own personal experience, even in hiring something as an intern or whatever, I often try to find out as much information as possible. And trying to find out, like, what, something about an information, some information about someone who's applying for a house or applying for a job or whatever, oftentimes biases that we may not even be conscious of may come into place. And so what this bill simply does is try to bring remedy to a situation that we know that exists, right? We all know that these biases exist in our society. And these professionals, for the second time, have tried to address the issues that was raised last year and has brought this piece of legislation for this committee to consider.
Well, with all due respect, my questions got to that, to identify the problem. People say there's a problem, and I asked all three, and I got an example of one time or heard that somebody did it. So I don't justify, or I don't agree that necessarily there's a problem unless somebody comes here and testifies to it. And then second point is, why would it not be an information for the seller to know if somebody has 20 or 30 breach of contract case searches in a Maryland case search? Why would I not want to know that information?
And you would want to know. I think we want to know. But one of the things that
Well, this would prevent it, would it not?
yeah, it would prevent it. It would prevent you from knowing their name. But one of the things that, well, yeah, I think, yeah,
Yeah, and that's a problem,
yeah,
I think.
gotcha. Mr. Chair, I think Senator Castley has his mic on. I know, it doesn't look like your mic is coming on.
Thank you. Yeah, so my question, and my father was not a Realtor, and I'm not an expert in real estate.
Neither was
or
mine,
anything.
Senator.
But this bill would say that not basically, what it says is, to do a real estate contract in Maryland, you have to have a broker. That's what this bill says.
No.
It says a residential, that you can't name the name, a residential real estate contract may not name the name of a buyer. Real estate contract shall identify a buyer's real estate broker instead. That's what it says. It applies to all real estate contracts in Maryland under this bill. So every real estate contract must identify a broker and not a buyer's name. It doesn't say an agent, it doesn't say anything else. It says must identify a broker. So what this bill says in essence is, every real estate contract must go through a broker. I know a lot of people right now just do their own contracts between Phil and Sue or whatever. But those would not be valid contracts any longer under this bill. You would have to, in order to have a valid real estate contract under this bill, you would have to have a broker. Is that your intent?
Yeah, no, the intent is for those individuals who are represented by a broker that this would apply.
Okay. And do we know what percentage of real estate contracts actually involve a broker at this time?
Oh, I don't. You guys have any idea? I don't think we have that answer available for us right now, but we could definitely inquire.
I mean, it's my, so I could sell my own home and I could sell it to someone who has an agent, we just wouldn't use a broker, right? You don't have to use a
Yeah,
broker.
no, absolutely. Yeah, you don't have to, you're not obligated to use a broker. You're correct.
It may not be your intent, but the effect of this bill would be that every real estate contract, in order to be valid, I mean, you could sell it, but it wouldn't be a valid contract. If the guy didn't go through, you couldn't sue him on it. Okay.
No, I apologize. Did I cut you off?
I don't know. That's
Oh,
okay. I'm not sensitive.
You know, JPR, you know, you guys operate a little bit differently. I just
raucous and
like to make sure that we hear each other. I think that could, if you know, and I don't have the bill in front of me, and you know, and I trust what you're saying. If that is the case, that it implies that that's not the intent.
Okay.
The intent was if you had a broker,
Okay.
that it would provide that opportunity. So we will welcome any amendment to clarify that.
And then my second question is, it says that a buyer shall execute with the buyer's real estate broker a separate document that identifies the buyer. I'm just trying to understand, what's that separate document? Would that separate document be a contract that lists everybody's names?
Presently, in the state of Maryland, the buyer would either A, elect to be represented, and they would execute a separate document we commonly call an exclusive buyer agency agreement. So that buyer is engaging the Realtor to represent them, or they would execute a separate document that the Realtor might not be representing them, but there would be a subagent of the seller.
Gotcha, but when that buyer doesn't go through with the deal, and I want to sue him for $200,000 for breach of contract, what do I put into evidence in court to say this was the buyer and this is the contract, and they're liable, not the broker?
If the contract were ratified under the bill as amended, the buyer's name will be added to the contract of sale on ratification.
On what?
On contract ratification. So you would have the name of the buyer as of the time of contract acceptance.
Okay, so you're saying upon this time that the ratification would occur when the seller signs the contract?
So correct. Once this contract is agreed by all parties, we place the date of acceptance on the contract. The name of the buyer would be placed on the contract as well. The bill as amended directs within 24 hours the name of the buyer to be placed onto the contract of sale.
This is
Would the buyer have signed their full name to this contract?
The buyer can sign their name. They could also, as amended, use their initials. The offer to purchase is absolutely signed by the buyer. It's initialed by the buyer. The buyer can use, as amended, their initials in place of their signature, which we understand is permitted in Maryland.
Right.
And so you have an offer to purchase that is signed by the buyer. If that's accepted, or once it's accepted,
Right.
then the date of acceptance is added to the contract as of that date, and then the buyer's name is added. That's the amendment to the bill, to say, we want there to be transparency. We want to combat the implicit bias that can sometimes root its way into a negotiation.
I guess that's my next question is, I'm kind of curious, I'm trying to sell my property. The person who comes in with the biggest bid, they get the property. I don't care, I'm leaving. I'm booking, I'm going somewhere else. I just want the money and go. I think I probably speak for 99.9% of most sellers that I quite frankly, as long as you're gonna pay what you agreed to pay, I'm done with this. And I don't care anything about you. I'm just trying to find out.
And we think that's appropriate, that
Yeah.
if that is the case,
Sure.
then there isn't any need for the buyer's name to
Right.
appear on the contract,
Yeah.
on the offer to purchase, because that isn't
Yeah.
a point of
We're just throwing
negotiation.
we're just throwing a lot of extra steps into real estate contracts, and it just,
It's to promote fair housing.
yeah, it is, but is it necessary? I guess that's the question that was asked before. Do we
Correct.
have-
The first
do we
question,
actually
is it
have
enough?
evidence that this is necessary, considering that overwhelmingly, most of us are driven by financial interests, and financial interest trumps everything else in our lives, and what we just want to do is get the biggest money we can get, and if, it's typically a bidding war where I put $220,000, and the next thing I find out is, well, you didn't get the contract because the next guy after you bid $225,000 or $230,000, and that's all anybody's talking about is who's got the highest bid, and.
And that's the focus. We want the focus to stay on the
Yeah, I'm just
price
trying
and
to find out-
term and not on the buyer.
I'm just not aware that that's not the focus. I've never heard that that's not the focus when it comes to the seller. I understand when we deal with landlord-tenant issues, where the owner is staying there, and you have, if, bias could creep in, and that's why we have the Attorney General does stings on this stuff and make sure that nobody's.
And I think I think we are limited on our experience, and I congratulate you that that has not ever made its way into your real estate experience. And we're here today because we believe that it does. And we want to ensure that there's an opportunity that, given precisely what you've stated, price and term is the most important thing, then it isn't necessary. And so if we're willing to wager and give up that curiosity of who the buyer is to ensure that the next person isn't discriminated against, I'm in. And we're here today to ask if you would also be willing to be all in on giving up the name of the buyer so that the next person can be assured that their name isn't being used against them.
And what if the buyer is Smith LLC or something like that? Does this apply then?
It does not, and thank you for asking. The Attorney General was concerned that entity purchases, that investment purchases would also be used to hide their identity, and that there might be this straw buyer hiding in the wings. And we have said absolutely not. We limited the bill to home buyers, primary residence only, so not for commercial properties, not for entity purchases.
I mean, because it would matter to me if it was Smith LLC, and I find that that's basically a shell corporation.
Correct.
And when they breach the contract, I can get all the $5 that they use to file for the corporate
We
entity.
agree, and we agree.
We agree. Yep.
Thank you, we agree.
Thank you.
Any more questions for this panel from the committee?
No, I just want to thank you, Madam Chair, members of the committee. I think you guys presented some really good questions. I don't think that this is a panacea that's going to solve all of the problems, but I think the professionals that presented here today and who brought this bill to me definitely are identifying their experience that, it's an issue. And hopefully we could find, with some slight adjustments, a way to address this issue here in Maryland to update, the fair housing practices that we have here in our state as it relates to residential real estate. Thank you, Madam Chair.
Thank you, Senator, and thank you, panel. And next up, we have the unfavorable testimony. William Castelli, are you here?
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. And we are signed up as opposition to the bill. This was the bill as drafted. We are reviewing the amendments. The only things that we would want to make clear is that even though we might state in this section of the code that initials are sufficient, there are other sections of the code that deal with statute of frauds, and it's not just about a signature, it's also about the identity of the party. So the language would have to address that. We also recognize that, the four corners of the contract are not the only area that a buyer might be identified. We just had a conversation about earnest money deposits. Sometimes there's proof required at the settlement or at the contract offer of earnest money deposits. It might be a check with a name on it. You also have pre-lender qualifications. You have a seller disclosure form that also has the signature of the buyer and the name. So it's trying to identify all of those things, and it's not just related to the contract itself. But we appreciate them reaching out, and we recognize this is an issue. We actually took a couple of steps within our own brokerage agreements to try to address some of this as well this year. That became effective in October. But we're happy to continue to work with them to see if we can find a solution.
Senator Castelli and then Senator Huff.
So how would you overcome that? Because you make a really good point, Ms. Castelli, that there's a contract, I'm going to pull my house off the market now, and you've got a contingency, it gives you 3 months to satisfy all the contingencies, and I'm going to pull it off, But it's certainly, before I do that, because the housing market may fall in there, I need to make sure that you're viable, and I am gonna wanna see proof that you actually are financially sound. And so now we're gonna have all those documents redacted with your name pulled out, but it's gonna still have your address in there. We're gonna redact all the addresses, because then you're gonna say, well, if you live in that neighborhood, maybe you're not a wealthy person, and maybe it's a minority neighborhood, so we're gonna redact all that. How does the seller protect their interest when, how would that work with all the potential disclosures on a contract?
Well, I mean, that's what we're trying to wrap our head around, is trying to figure out how this works. I mean, in theory, yes, it would be great if you had, a technological solution to it where, these documents could be submitted electronically with attached to an actual identity. But we are trying to, because, we agree, this problem does exist. The Massachusetts case that they cited, and you don't often find this out from a seller, but this seller was very clear about why they chose, after they had indicated they were interested in the offer, once the offer was submitted with the name Ebening on it, they were very clear about why they were no longer interested in the offer. So it does happen. We are interested in finding solutions to it, and we look forward to working with Senator Hayes and these folks.
Thank you.
Yeah, I mean, look, there's no doubt there's definitely idiot people out there. I mean, that's for sure, but it's just trying to figure out a law. So I'm trying to go back. So when it was testified that there is not information, or they're not providing information on the seller anymore, or information of the prospective buyer to the seller, but I seem to remember every time I've gone to buy a house, we provided with a form from the bank saying we had been pre-approved. And that was a pretty common practice, especially because the market was really hot, so they wanted to see that you had a pre-approval letter. And I think they actually asked for it, or we offered up. Isn't that still a common practice?
Yes, Senator, and that was one of the items that I just mentioned was, with some of the pre-qual letters, you might have identity, and it's not just there. The seller disclosure form is required to be given with the contract as well. You've got signatures and identity of parties on that as well. So there are other documents outside the four corners of the contract that could potentially identify that buyer. So,
Yeah, and the idea that someone's going to anonymously buy it, I guess they could, but they also show up usually with a home inspector to go through the house, so you're going to see the person that's going to buy your house, correct?
well,
I mean, they walk through the house with a home inspector. They're going to walk through the house at some point. I know that you do a lot of virtual selling, but I got to imagine that the common practice is, we're creating all this whole law to create an anonymous buyer, but they walk through the house for a home inspection, right?
it depends, though. In the kind of market we're in today, where you have
It's sight
a
unseen
tremendous
right
amount
now, yeah.
of people walking through a property, it's very likely they're not going to have any clue who the people are that ultimately submit a bid.
It's kind of like you're kind of making the point with the market right now. You're making the point that we're kind of making that aren't most of these decisions market oriented, that they get a really high bid and they're just selling it, correct?
So, yes, we would hope, and we do think that most of these transactions are market-driven.
Yeah.
But we do know, we know because there have been cases, we know that we suspect in other cases when you have a party that says, for example, offer sheets. A lot of times those are anonymous. So in a very active market, you might have 7 different people who have made an offer. The real estate agent and the brokerage would type up an offer sheet. Oftentimes that is anonymous. It's just 1, 2, 3, 4, 5, 6, 7. Seller takes a look at it, says, I want offer 3. You go, you provide the contract for offer 3, and then suddenly they see Castelli as the last name, or, some other ethnic name on it, and they're no longer interested in offer 3, despite the fact that 24 hours earlier, they love that offer. So, I mean, there are just instances like that occur, and it's just trying to figure out what the mechanism is that works, and I guess that's our interest.
Okay.
Senator West.
Thank you, Madam Chair. So, Mr. Castelli, I come back to my earlier point. Isn't it just human let me start by saying, if in fact there are people who would discourage a seller from selling the house to them because of the way their name is spelled or their race or other information about them, then conversely, there are people who would encourage a seller to sell their house to them because the way their name is spelled or their race or whatever, correct? I mean, what's on one side of the coin means there's something on the other side of the coin, right?
Yes.
So this bill would not prevent the people who believe that it would be advantageous to them in getting the house that they want to make sure that their identities became known to the sellers. It stops the name from being put in the contract, but there are lots of other ways in which a prospective buyer could make sure that the seller knew who the buyer was, right?
Correct.
And in your experience, wouldn't you expect that to happen in the real world? Wouldn't you think if a buyer really wanted a house, that the buyer would make it his business or her business to make sure that information about them which would be advantageous to them came to the attention of the seller?
That is happening now. In fact, that was one of the changes I referenced earlier that we've made as an industry practice, which is dictating that licensees through our brokerage firm are not going to be submitting love letters. That's one of the ways that a buyer might let a seller know about personal characteristics that they think that would appeal to the seller. I've got 3 daughters, you had 3 daughters, we went to the same college, whatever it is, just to make it clear that licensees aren't going to be part of the process of submitting that. But that doesn't mean, it's free speech. If a buyer wanted to reach out directly to the seller, they could.
And let me finally come back to the licensee issue. When we bought our house in Rehoboth, we worked with an agent. And the agent seemed to be trying to help us to conclude a sale. And once the sale was concluded, the agent shared in the commission. So it's only human nature for the agents want the people that they're working with to succeed in buying houses. So wouldn't it be logical in the real world for an agent to be advising prospective purchasers about how they could enhance their likelihood of getting that house?
Yes. The problem is, so taking the love letter example, and I'll just be very quick, the problem is that, almost any real estate attorney that you're going to talk to across the country is going to advise against it because it steps right up to the line of fair housing. So when an agent is advising that buyer about what is the best way to differentiate your offer, it's usually price, maybe limiting the types of contingencies that you're willing to agree to or not agree to, whether you're willing to forego an inspection. So there are lots of different ways that relate exactly to the property and the transaction that have got nothing to do with all of the personal characteristics that we would associate with a fair housing law. So I do think that an agent doing their job is going to be focused on those things as a way to direct the buyer in an appropriate way for them to, basically shine light on their offer compared to other offers, but that doesn't step right up to the line of a fair housing issue.
Gotcha. Thank you.
If there are no more questions, that concludes the hearing on Senate Bill 678. Next up, we have Senator Benson and Senate Bill 681.
Good afternoon, Madam Chair, members of this committee. Before I get started, I have been down here in Annapolis for over 25 years. And when I present a bill, and I'm sure you all understand that getting a bill prepared for presentation takes a lot of time. It's a lot of research. We have to utilize the services of the attorneys that are down here. The people in my office work very hard to compile bills that we feel are in the best interest of the people that we serve. My reputation down here in Annapolis, and this is before I give you my testimony, my reputation down here in Annapolis has been looking out for children, senior citizens, the disabled, the veterans, the working people, the little people, the people who can't speak for themselves. And I want to say to the people who are opposing this bill today, I looked at the list of the people who are opposing this bill. And Madam Chair and members of the committee, the people that are opposing this bill, are the people that I have always been supportive of, and they've always supported my agenda because they understand my passion and the kind of heart that I have to serve the least of these. You know, it's kind of upsetting when you have these people who know who I am and what I stand for, who did not have the respect for me to come to my office to talk to me about this bill. That's very troubling. That is very troubling, and I want them to know that. Some of these people have been my staunchest supporters. They have been. Both in coming down to give testimony, but also when I have a fundraiser. I may as well tell you the truth about it. But it just bugs me to no end that when I get up here and I begin to look at this folder and see the Maryland Board of Realtors, who just in Prince George's County walked with us in it was Prince George's Realtors, who walked in my community, went to the little church that I work out of, gave $2,000 worth of underwear and socks for our children in 5 of our targeted schools, and they're here opposing this bill that is designed to help the very people who are from families who receive these socks and underwear for these baby children. I don't just come here for foolishness. I come here and I stand before people on these committees to deliver a bill that's going to help not Joanne Benson, but for the people who can't speak for themselves. And I felt so compelled to just get up here to tell you all how deeply troubled I am at the people who are here disagreeing with this bill. It just is so troubling. And with that, let me proceed on. Now that you all know how I feel, I'm very passionate about the things that I do down here. I'm just not out for a lot of foolishness. And this is very, very troubling. So good afternoon, Madam Chair, members of the Judicial Proceedings Committee. I am here to present Senate Bill 681, Real Property Residential Leases, Fee in lieu of deposit. This bill is for the purpose of helping stabilize the economic impact that occurs with tenants when trying to move into a new property with a new landlord. A security deposit is a sum of money that a new resident gives to their landlord or property management company in addition to their advance rent payments. As we all know, security deposits can be a sizable fee, which can prevent potential tenants from renting housing. Today, tenants in Maryland must pay up to 2 months' rent for security deposit, in addition to the first month's rent. At an average, Maryland's rent of $1,700 per month, renters could need up to $5,000 due at move-in. Marylanders need a new tool that can help them have access to housing, particularly those without financial means, to afford hefty security deposits. Those with a new and or difficult financial situation, or persons who need to find new housing quickly. This bill's purpose is to allow landlords to offer a tenant the option to pay a monthly fee that would waive the security deposit. The tenant would have the option to accept that option or pay the traditional security deposit. Furthermore, if the tenant chooses the fee option, the landlord must purchase insurance against loss, rent, or damage, and the fee must be within the reasonable cost of the unit's insurance premium. The landlord is the policy holder, and the tenant is still responsible for paying the rent and for damages incurred under the terms of the lease. When the lease has ended, the landlord must provide the tenant evidence of any damage or outstanding rent. The bill will also include provisions that are unique to the state of Maryland, including a one-month security deposit limit if a landlord offers the option to a single tenant in the building. This bill would give tenants the ability to be flexible with their funds when in the process of looking for housing, while giving the landlord the ability to still be covered if any damages are incurred during the tenant's tenure or at the residence. Additionally, tenants will be less likely to be behind on rent payments during their time at the residence due to significant security deposit fees that can cost up to 2 months' rent in addition to the first month's rent a tenant must pay. This can set tenants back a total of 3 months on payments if they are in a difficult financial situation. Reality is that most people, and I've lost the second page. Y'all bear with me a minute, please. Most tenants are living paycheck to paycheck, and a large security deposit is not helpful to those who are in that situation and are looking for housing. Therefore, I respectfully urge the committee to issue a favorable report for Senate Bill 681. And I'm going to have some people to come up to testify in favor of this bill. And if you all will be kind enough to excuse me, I have another bill that's downstairs that I must testify on. And it is not because I want to be disrespectful and walk away, but I do have another bill that I must testify on. And I certainly hope that you all would give this bill a favorable response. I thank you all very much. And hopefully the people who are coming up to testify favorably on this bill can answer the questions that you may have. Thank you very much in advance, and thank you for all that you do. And I certainly look forward to seeing you all real soon. Thank you very much.
Excellent. Thank you very much, Senator Benson. All right. With that, we'll take your panel, and we'll call up Ms. Howard, Ms. Grimm, Mr. White, and Mr. Wiggins.
Good afternoon, Mr. Chair, committee members. I'm Kathy Howard. I'm with the Maryland Multi-Housing Association. I am their legislative co-chair for at least the next few months. We are favorable with amendments on this bill. I think that we all understand what Senator Benson, the sponsor, has suggested, that it is very difficult sometimes for folks to deal with security deposit requests when they are going in to rent a property. And this bill, I think, attempts to give an alternative to a security deposit and the security deposit law. Unfortunately, however, I think that the bill itself is has a lot of very complicated provisions in it which need to be addressed. One of which, in particular, that gives me some heartburn, are two things. One, on page 3, it talks about giving the tenant the option, if they decide not to do an insurance policy that is allowed under this bill, that they would only be responsible for 1 month security deposit, which flies in the face of the current security deposit law, which allows a landlord to ask for a 2-month security deposit. The second thing is page 7, lines 9 through 27, become very problematic if there is a dispute over what is charged to the tenant after the end of the tenancy that is supposed to go under the insurance policy. If a court finds that that there is some small mistake or some small item that is not allowable, that completely voids all of the charges that are being charged under the insurance policy. And I think that is a very problematic provision that needs an awful lot of work. I think that there are other provisions that some of the other folks here are going to talk about that give them some pause about this, and I will take any questions later if you would like. Thank you.
Mr. Chairman, members of the committee, my name is Josh White on behalf of LeaseLock. And on behalf of LeaseLock, we want to thank Senator Benson for sponsoring the bill that would give tenants an option to the current security deposit law. As you all know, it's not easy to come up with a security deposit. That could be first month, last month, and the security deposit. We can be talking about $5,000. In last session, this committee asked us, we had the bill in last year, and the committee asked us to address some of the concerns that the tenant advocates and the Attorney General and others like MMHA, and we were very thankful for all the time and energy they put into the bill over the last year. We spent an awful lot of time on it, and in that process, we adopted about 20 provisions or so from all parties, and we wanted to come up with a bill that actually will tackle this problem of security deposits. And we also want to thank, in particular, Matt Hill from Public Justice Center, who just yesterday gave us attention to a provision that was left out of the bill, which would be Amendment 4 that we will submit to as a sponsor amendment to the bill. And as well, we want to thank everyone for their time. Just today, many members that are going to come up here to oppose the bill have told us about provisions that they also want to discuss now. We are happy to do so, and we hope that we can move ahead and provide this option to tenants and landlords. This is things that happen in 30 other states. We want to make sure it's a very transparent process, and we hope that this committee will understand that this is an option that is favored by 90% of tenants who do have this option. So I think by having the ability to look at it, we hope the committee will give it a favorable report. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Christopher Grimm, also testifying on behalf of LeaseLock in support. It's already been talked about how much of a hassle security deposits are. When I got my first apartment, I remember emptying my bank account and the stress that caused, as I lived until my next paycheck was significant. And I know I would have loved an option to have paid a fee of $25 to $30 a month to waive that security deposit requirement until such time as my savings account was big enough that it wouldn't have put me out the way it did. This bill would create clarity in the law around this alternative, which is a landlord charging or offering the option to the tenant of a deposit waiver fee. It's needed because the current definition of a security deposit in Maryland is so broad that it would require a deposit waiver fee to be refundable, which makes it no longer a fee, it just makes it a security deposit. So this would create that clarity, and as was stated, it would introduce a significant number of protections for the tenant. Interestingly, the current protections around a security deposit don't apply to tenants that don't have to pay a security deposit. So this bill would apply all of those protections that apply to a landlord withholding a security deposit to landlords that are offering this fee option or any other third party that the landlord then contracts with, to collect a debt, or if they sell the debt, or to an insurer like LeaseLock that pays the claim. It extends those protections as well. LeaseLock is involved in this as an insurer. We provide insurance to landlords. Once they have that coverage, they can then offer tenants the option of paying this waiver fee instead of the security deposit. And LeaseLock sort of formed when our founder couldn't come up with a security deposit. His first apartment in New York City, couldn't afford the security deposit. He thought there has to be a better way. There are some other options in the marketplace, but they're not great. So he started LeaseLock as something to be a win-win that would lower the barrier to housing that is a security deposit for tenants and still provide significant coverage for the property owner. I'm happy to answer any questions.
Good afternoon, Mr. Chairman, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I think Kathy covered it pretty well. I do just want to touch on a couple things. First, let me thank LeaseLock. They have been in ongoing discussions with us. They reached out to us somewhat early in the process, and we understand the concept and we're willing to work on the bill, but we do think that the current posture of the bill needs a lot of work. I just want to point out a couple of highlights in our written testimony, which I would encourage you to read. On page 7, the bill exposes housing providers to unlimited liability in any court proceeding for any material violation of the section. There is no maximum liability. There is only a minimum liability. Any noncompliance, no matter how small with the statute, results in complete forfeiture of all unpaid sums. A typo in the notice would result in voided claims against the tenant and the insurer. So as I read the bill, if you have a typo in your notice, even if it's a lower amount that you're trying, if you write a 4 instead of a 5, it voids all future claims for that amount. I've never seen anything like that before. And so for that reason, the bill needs a lot of work, but we are open to continued conversations. Thank you.
Excellent. Thank you very much. We'll move on to questions from the committee for this panel. We'll start off with Senator Huff, and then we'll go to Senator Watson.
I mean, I think it's a good idea. I'm just looking, you got a lot of testimony from the judiciary and some others. Have you seen the judiciary's testimony yet? Have you had a chance to look at? You might just want to look at that afterwards, because they bring up a couple things that you're going to have to address if we move forward on it.
Got it.
So-
Happy to take a look and address any concerns.
Yeah, the judiciary brought up a couple things. And then something else I noticed that Maryland Multi-Housing and the Realtors brought up, the 1 month versus the 2 month issue.
So the intent of the language in the bill is and only if a landlord is offering the option of a fee instead of a security deposit. Once they're offering that option, their security deposit would be limited to 1 month's rent. And that was brought to our attention from, I believe, the Attorney General's office or one of the tenant advocates. The concern there was that a landlord may currently be charging less than the statutory limit for a security deposit, and there was concern that this would then inflate. So, for example, if the rent was $1,500, but a landlord was only charging a $500 security deposit, this option would incentivize the landlord to jack up, so to speak, the security deposit requirement, and that would sort of tilt the scales a little bit on the choice of paying the deposit or the fee. So this 1 month limit would only apply to instances where a landlord is offering the fee, which is totally optional. There's nothing in the bill that would require the landlord to offer the option or a tenant to pay the option. The trigger that I think you're referring to is just if you're offering the option, there's a limit of a 1 month security deposit.
Yeah, and I mean, it just seems to be the Realtors and Maryland Multi-Housing both brought up that point. It seems to be a sticking point that they don't want to get away from the 2 month. At least that's what was my reading of it. I mean, it seems like
I think that's a fair point, and I think that's an issue for the committee to determine.
I mean, I like the concept, but it's just my quick look at it. It's going to need work. I mean, if you're going to need Maryland Multi-Housing, and especially to address what judiciary's concerns and the realtors, so it's a good concept, just you're going to have to work through a lot of this.
Happy to, and we already have some amendments in that I think would address some of the concerns that were raised on the liability issue. And then I think there was a lack of clarity currently in the way the section about the 1 month security deposit is currently drafted, that it could be read to apply to sort of all circumstances, and that's certainly not our intent. So we have an amendment to make sure that that's really narrowly focused to just the instances of a landlord offering the option.
Okay, thank you.
Thank you, Mr. Chair, and thank you all for coming. I've had the opportunity to talk to Mr. Grayson about some of my concerns, but some additional questions. You as lease lock, you currently engage landlords now in this process?
We do not currently in the state of Maryland. We used to, and then an interpretation of the statute that I mentioned earlier about the security deposit statute was brought to our attention, and we have voluntarily ceased to operate under this model in the state.
Do you do it in any other states currently?
30 other states currently.
And in those states, what is the average deductible that a landlord would have to pay?
So our average premium nationwide right now is $27 per month per unit.
What is the deductible?
Oh, sorry, I thought you meant the premium. The deductible, there is no deductible, so our coverage is up to $5,000 in lost rent and damage, but there is no deductible.
There is no deductible. So that's the distinction between most other types of insurance, like a homeowner's insurance.
Correct.
All right. Based on the way the bill is written, if a the interesting thing about this, the bill we heard earlier talking about buying and selling property, it literally was all about dollars, right?
Mm-hmm.
Get the money. As a landlord, of course you want your money up front. That's just the way it is. Now, I think it's great that a landlord would have flexibility to offer this to a tenant. However, the way the bill reads, if you offer it to one tenant, you have to offer it to all tenants, irregardless of whether they can come up with the deposit or not. Is that correct?
So I believe that's correct. The intention of that provision is to, is sort of in the spirit of fair housing laws. This was another state that we were pursuing legislation in. The issue was raised, oh, could someone use this to discriminate against possible tenants? And could say, you're a riskier tenant, I don't want to offer you the fee model, I want your security deposit because I don't want to have to go through the trouble of submitting a claim. And so that provision is sort of in the spirit of fair housing laws. So I don't know that it would apply specifically to situations where someone could or could not come up with a deposit. It is really just intended to ensure that everyone in a building is given the option if one person's given the option.
That poses some problems for landlords. You know, I've said this before related to these types of bills, there's this balancing act. You got to have enough money in reserve to handle those unforeseen things, like in any business, right? And if you give somebody the option of paying up front or giving them a fee, just say 80% of them take the fee, the landlord is at risk. He's at risk. And the landlord does not have the flexibility at all, the way the bill is currently structured, to say, I'm going to help, these tenants. I understand that they're maybe a lower income. These folks can afford it. Why not get the money from them? And in trying to make it fair, it seems that it would be unfair because you're putting additional risk and burden on the landlord. I just think that needs to be thought out just a little bit. I would love to help people. I've helped people many, many times. And then there are other folks who are transitioning from the military. I know they got the money, and they have no problem stroking a check for, first couple months' rent.
So I appreciate the concern there. This is where the optionality of this all comes into play.
But once you take the option, once the landlord offers it, it's no longer an option for any subsequent transactions the landlord is going to do. Is that correct?
As long as they continue to offer the fee. So if landlord offers, let's say you're a landlord and you sign up with lease lock. Every new unit that you're offering, every new tenant that comes in, you would offer the option of paying this fee or paying a security deposit.
Lease lock would cover all of my properties or cover each unique unit?
Each unique unit.
So if I have lease lock on unit A and I offer it to you, and now I want to rent Unit B, must I still offer that?
Correct. Once you no longer offer it, though, that's it. So like let's say you've got 5 leases that are currently covered by lease lock, and the 5th one is expiring in 2 weeks. You don't have to continue with lease lock, right? You can give notice. I no longer want to work with your company. I no longer want to offer this option. And then once you're no longer offering the option, you no longer have to offer the option. So that's certainly the intent.
So I have 5 units, and as long as I have an active engagement with lease lock on one of those properties, I must offer that flexibility for all the other 4.
Yes.
Okay.
I believe that is how that would work.
Even if the other properties are in different parts of the region.
Oh,
where
it would
the
just be
income is
building.
higher.
It would just be building by building. And I think we can certainly, I mean, that's the intent of the language, is for it to be building by building and not span an entire
So you're talking
portfolio.
one specific building complex with multi-units in a specific location, not disparate locations?
Correct. That's the intent.
Okay. All right. I look forward to seeing the amendments and see if we can clean this up.
Yeah, sure.
But I appreciate the intent.
Absolutely. And I think we're happy to address that in a way that works for everyone. I mean, that's our goal with all of this.
Okay, thank you.
I'm just trying to understand the whole picture here. So I know before the Attorney General came into the picture in Maryland, you were charging like $19 a month for a tenant, for the fee, and provided that, and they would pay that fee every month, and if that tenant completed the lease, didn't breach, they move out, you were keeping the $19 a month, and the Attorney General said, no, you can't do that, you have to return the full amount to that tenant. So that's where we are now. If tenant A, who pays everything, they're a great tenant, they do the fee, lease is over, they leave, all those $19 a month, they all come back to the tenant. So that's where we have to be. Now you have tenant B, who screws up, they stay for a year, but they breach the lease, whatever. They've been paying $19 a month for a lease lock fee. So they would forfeit their $19 a month, and you would have to pay up to $5,000 to the landlord for whatever rent was due or damages, right?
Correct.
Okay. And does the landlord pay an additional fee because they're using lease lock, or it's just the tenant's monthly?
This might be a good opportunity to kind of just step back and explain the process, because I think that might answer some of the questions. So once we provide, so let's say we sign up a new apartment building or a new portfolio of properties, we'll do an underwriting, we'll come up with a loss limit that works for that property or that portfolio, right? It goes up to, we do up to $5,000 in both lost rent, damage, fees, right? Anything that's covered under the lease that the tenant's responsible for, we will cover.
And the fee would vary depending upon the risk of that building?
Of each building or portfolio of buildings,
Right.
correct. It is not on a tenant by tenant or unit by unit ratio.
The fee would be for that building?
Correct.
Okay, depending upon the risk of the building. Okay.
So then every tenant who opts into the fee would pay the landlord that waiver fee. The landlord waives their security deposit requirement. The landlord's then paying that fee to lease lock as their premium. When the tenant moves out, or let's say there's another event that causes losses, an eviction, or something, once there's no longer tenancy, the landlord would submit a claim to lease lock. If it's a valid claim, right, and evidence, right, just like if you get rear-ended, you have to submit, evidence to your insurance company. Evidence of a valid claim, we'll pay the claim, and then as a matter of our business, lease lock ends the issue there. We don't collect from tenants, even though under insurance law, we have that right to do so. So that's sort of how the process works, kind of from the time a tenant is given the option until the time, they move out. If there are any outstanding charges or indebtedness, what happens to that indebtedness? The tenant is still responsible for the terms of the lease. So before the landlord would submit a claim to lease lock, they would first try to collect from the tenant. And in your circumstance where the tenant had paid their $19 a month, they moved out, let's say there was $800 worth of damage to the unit, they always will get a bill because they're always responsible for the terms of the lease, right? Paying a security deposit doesn't absolve the tenant from the terms of the lease. If there's more damage than the landlord held in a deposit, they're still responsible for those charges. In this case, the tenant would have gotten a bill for $800. In 30 days, if they didn't pay, the landlord would submit a claim to lease lock. Again, valid claim, we'd pay it, and that's where it would end.
But the breaching tenant doesn't get back their $19, let's just say it's the $19 a month. The breaching tenant doesn't get back their $19 a month.
Correct.
They forfeit that. So what if they stay there for, 2 years, they paid a lot of $19, what if that amount is more than the damages you're paying to the landlord? They still forfeit all of that?
So it's not a forfeiture because it is a non-refundable fee. This is why we're currently not operating in the state.
It's only non-refundable if it's only non-refundable, the fee's only non-refundable to the tenant if there's a claim by the landlord.
No, the fee is always non-refundable.
Okay, I thought that's what the Attorney General's suit said, that you couldn't have them as non-refundable and that the fee must all be returned to the tenant if they abide by the terms of the lease.
Correct, that's why there's a bill to sort of clarify that,
Okay,
right?
so
If
under
it
this
is
bill-
refundable, it's not a fee, you're essentially just creating an installment payment for
Okay.
security deposit, which is a separate
All
issue.
right, so under this bill, even if I'm a tenant, I take this, it's $19 a month, I pay that, I stay there for 2 years, I leave, I've never paid a security deposit, so I don't get back a security deposit, but I also don't get back the $19 a month, right?
So you wouldn't pay a security deposit in this circumstance. It's
Right,
not in
right, I
addition
understand
to,
that.
it is instead of.
Right, but I don't get back, under this bill, even the non-breaching tenant does not get back their $19 a month. right?
Correct.
Okay.
The value proposition for the tenant is large upfront security
No, I got
deposit,
it,
potentially
versus $19 a
refundable
month.
versus the fee.
Okay, so this bill basically takes what the problem the Attorney General identified and just resolves that and says you can get the $19 a month and they don't have to be fully refundable.
Correct,
Gotcha.
and then carries through significant protections for the tenant.
I understand, I got all that. Okay, thank you.
Thank you, Mr. Chairman. A quick question. So in the scenario that my colleague proposed with, I don't pay my rent, right? And I leave, and I owe the landlord $800. I don't have it. They can be covered by the insurance that they have through lease lock. But what happens to me? Am I still on the hook for that $800? Are they still coming after me for that?
So who is they in that circumstance?
The landlord
So-
and the tenant?
Yes, so the tenant is still responsible for the terms of the lease agreement.
No, they don't.
Paying a $25 a month fee, right, does not absolve you from owing $800 or $1,800 or any amount at the end of your tenancy.
So is it possible then that the landlord is going to be compensated, get $800 from you, and still go after me for my $800 and get a windfall?
So no, two reasons why. One, that's insurance fraud. And two, there's a specific line in the bill that would prevent the landlord from doing that.
Okay. But wait a minute, but I'm still on the hook, you said.
Yeah, so again, the landlord would bill you at the end of your tenancy for any outstanding charges.
Right.
If there's a failure to pay, the landlord would then submit a claim to an insurance company.
Right.
The insurance company pays that claim. The landlord can no longer pursue the tenant. Let's say on the 29th day, you put a check in the mail and the landlord gets it on the 40th day and they already got paid by the insurance company. They have to return the funds to the insurer, right? The tenant is still responsible,
Oh,
right? Just as if you had paid on day 20, right? The tenant is still responsible. They can just no longer pursue you once they've been paid from the claim.
okay. Thank you.
You're welcome.
Thank you, Mr. Chair. So the landlord can't pursue them, but what about the insurance company, which has paid $800 to the landlord? Can the insurance company pursue the tenant?
Yes, they can. Under current insurance law, right, the insurer always has the right to pursue the damaging party. If I rear-end your car, I don't have insurance, your insurance is going to pay for that. You're not going to pay a dime, but I'm definitely getting the bill.
Right. I know, I just wanted to close the loop on that. Thank you.
All right, seeing no further questions for the panel, thank you all very much.
Thank you very much.
All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. We'll have Mr. Kemmerer, Mr. Hill, and Ms. White.
Chairman Smith, distinguished members of the
Judicial Proceedings Committee. My name is Hannibal Kemmer, and I represent Attorney General Frosch. Today I'm here to testify in opposition to Senate Bill 681. We have three principal reasons why we oppose the bill. First, under this bill, tenants may pay more than 2 months' rent as across a long-term lease, whereas under current law, Section 8-203 of the Real Property Article, the amount of a security deposit is capped at 2 months. Same thing with a surety. If you were to buy a surety bond, it's also capped at 2 months. The second reason we oppose the bill is because the landlord may charge more than they pay the insurer. So in the case of lease lock, let's say the landlord contracts with lease lock to pay $19 a month. They can charge the tenant an indeterminate amount every month that, so that they make money on the margin. The third reason we oppose the bill is because there's no parity of contract between the tenant who's supposedly benefiting from this and the insurance company. Instead, the contract is between the landlord and the insurance company. So, in a worst-case scenario, a tenant may pay dutifully for years and years and years, may end up moving, and the landlord maybe never provides them notice but claims to lease lock that they've messed up the property. And under those circumstances, the insurance company could seek subrogation. We just heard from the people supporting the bill that they can seek subrogation under our laws. So the tenant might not have any idea where this is coming from, but be confronted with a lawsuit much further down the line. So for the foregoing reasons, we oppose Senate Bill 681. I do have to say, we adore Senator Benson, and it's not easy to oppose her bills. I'll take questions at the conclusion. Thanks.
Good afternoon, Mr. Chair, members of the committee. Matt Hill, attorney at Public Justice Center. I'll start with where my colleague left off. We adore Senator Benson, do not easily oppose her bills. I also want to appreciate Lease Lock and their representatives for working with us on this bill and addressing a lot of the concerns that we raised. The bill is significantly better than it was last year. Having said that, we still submitted opposition testimony. Prior drafts of the bill did include this provision that said the landlord cannot charge essentially more than what they're paying the insurance company. We don't want this fee to become a profit center for landlords. I understand from Lease Lock that the amendment will be provided to address that issue. That's a good thing. Mr. Kimmer raised an important issue around not exceeding the 2 months rent security deposit. You don't want someone to be paying and paying and paying into eternity. And then I think that another issue that recently came up, and again, I've been working with Lease Lock for a while to try to address some issues, but I just learned from a colleague in another jurisdiction that at least some company, I don't know if it was Lease Lock, was charging a variable fee. So if a tenant's credit score went down, the amount of the fee they paid each month went up. And that seems very difficult for a tenant to plan and budget. And so that's an issue. We understand that some of our colleagues from MMHA may want to remove the provision that says these charges are not rent. That's an important provision in the bill. We want to keep that provision. In other words, rent should be rent. It should not include these additional periodic fees that could cause someone then to be evicted if it's deemed to be rent. And then finally, I admit, could get to neutral. I'm not sure we could get to favorable because it is just difficult to explain issues of subrogation and think that consumers and tenants understand exactly what they're getting into in these kinds of more complicated transactions. Having said that, I'll rest for now. Thanks.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of the Maryland Consumer Rights Coalition. We work on economic rights and equity through research, education, advocacy, and direct service. I also love Senator Benson, and I'm very sorry to be here in opposition to this bill. I do want to thank the proponents of the bill who we have been in very productive dialogue with over a number of months. But at the end of the day, we just thought that this bill is not ready yet, and we have some remaining concerns and unanswered questions. My colleagues have covered a lot of issues. A couple that I want to mention. As Senator Heddleman mentioned, an insurance company could later pursue someone for outstanding debt. And I have issues about that jurisdiction. I know right now we do work on auto insurance and other kinds of insurance, and consumers very rarely get redress when they file administrative complaints right now in Maryland, and it's very hard. Many people don't know how to pursue any issues they had with an insurance company if there are issues around the claim. And we know that there could be later debt collection activities, which I have very strong feelings about and lots of concerns about, through the insurance pursued later. I also just have questions. This is these are third-party companies. These are startup ventures in many cases. They're funded by investment firms, and it's not clear to me what will happen if a company goes belly up. Frankly, if you look at WeWork, for example, you see that company just collapsed, and what would happen to all of these tenants who had these agreements and contracts in that kind of place? It's not clear at all what kind of provisions or what would happen to them, how things would be resolved. So we appreciate the problems. We all agree about security deposits being a problem for low-income and working tenants. One thing we could do is just look at installment contracts or installment payments for security deposits as another option. But we appreciate the work, and again, appreciate continued dialogue with the proponents on resolving these issues. Thank you.
Thank you, Mr. Chair. A question for Mr. Kemmerer, I guess. So, Mr. Kemmerer, if I buy a house and I can't afford to pay the entire price of the house up front, I take out a mortgage. And over time, I pay more money because I took out a mortgage than I would have paid if I'd paid for the house up front, right?
This is true, yes.
Yes. So now, in the case of this situation, renting, normally you'd have to put down 2 months' deposit. But if I don't have enough money for 2 months' deposit and instead prefer to pay a small amount each month for insurance, I concede that over time, the total amount I pay for the insurance might exceed the amount of the 2 months' deposit. But isn't this just as advantageous to renters to be able to not have to pay the big deposit up front and pay smaller amounts each month, just as advantageous to them as it would be for a person buying a house to pay the mortgage in smaller amounts each month and not have to pay the whole amount up front?
Well, Senator, I think, as you well know, home ownership is one of the greatest wealth building abilities that Americans have. So I don't think, the fact that we can take out mortgages and pay them over time is really the same. You're not going to build wealth renting from anyone, whether you have insurance or not. And that insurance inures to the benefit of the landlord, not the tenants. So, no, I think it's apples and oranges, frankly, sir.
All right, seeing no further questions from the committee, thank you all very much. That'll conclude the testimony from this panel and the hearing for Senate Bill 681. We'll now move on to Senate Bill 452, and I'll ask Senator Lee to just take the helm here while I testify. Awesome. All right, good afternoon, members of the committee. Senator Smith here to testify on behalf of Senate Bill 452. I just wanted to like to bring up Kat Highland, David Schlee, Steve Sakamoto-Wengo, Chris Dews, if he's here, Amy Hennon, Marceline White. Y'all can come on. It's like an all-star panel here. All right, so essentially the thrust of this bill is that it would eliminate body attachments for small claims, so claims in district court under $5,000. Now, the way that the current process works is that a creditor who has secured a judgment against the debtor, oftentimes need to understand the assets of the debtor, and so they can do this through a number of ways. The most common are through written interrogatories in aid of execution, which are basically questions to find out assets to the debtor. They can also do an examination in aid of enforcement of a money judgment, which is essentially a court hearing. And so the judgment creditor, then the next step is that if they can request a show cause order if they have proven that the debtor has ignored the request to answer those questions, and that there was an order from the judge compelling the defendant to answer those interrogatories, or if the defendant failed to appear for that court hearing. So you can get that body attachment essentially for those two reasons, and that's an effort to get that information from the debtor. So if the judgment then fails, then the body attachment gets ordered, and then that person can be arrested and incarcerated. So what Senate Bill 452 does is it prohibits an individual from being arrested or incarcerated for a failure to respond to an order to appear in court for an examination in aid of enforcement of a money judgment entered in small claims court, so under $5,000 district court. And the reason why we need this is because the reality is, and I'll quote our Attorney General, and we have a representative from the Attorney General's office here, is that the use of body attachments to collect civil debt is not only questionable constitutionally, but it also is an outdated, unfair, and draconian process that hurts people of limited means and has a significant disparate impact on people of color. Again, this bill only covers judgments under $5,000. I'll give you a few statistics to kind of show you this disparate impact on communities of color that I've received from the Maryland Consumer Rights Coalition. So from 2015 to 2020, Maryland judges issued at least 756 body attachments to enforce civil judgments against those in debt for small claims. And if you just kind of disaggregate that, you go and you look at the zip codes where these body attachments were issued, and the 5 zip codes that had the highest numbers of body attachments contained 81.24% of persons of color, and the top 20 was about 81% people of color. And so the bill, actually, you'll see we have a diverse panel here of disparate and diverse interests. This bill is actually the product of work from a negotiation for the Creditors Bar, the Attorney General, Consumer Rights Coalition, all of whom support this bill. And so with that, I'll stand here, rest for questions, and I'll turn it over to the panel.
Any questions? Senator Carter.
Thank you, Madam Chair. Senator Smith, when I first saw the bill today, I thought to myself, I feel like I've seen this bill from a long time ago.
That's right.
And then I just looked at the fiscal note and saw that there was some action in 2013, and then not again until last year. And I'm not even sure if you were the sponsor of last year's bill, but if so, I wanted to know, why didn't we pass this bill?
You know, that's a very good question. We were otherwise occupied, but a very good question. A lot of good work we did this committee, so I'm hoping we can.
Working with the coalitions, is this the same language?
No, this is the same posture. So my delegate Moon had this bill last year. It passed out of the House. I think we were in receipt of it. We just didn't take action.
Thank you so much. And really, if I could just take a little bit of liberty. So I've had an experience where I had a client that I represent in something else who called me in a panic one day saying that he received something at the House saying that he had to turn himself in, the way he thought it, turn himself in on a warrant. And I was like, well, what is it? Because, I'm all used to criminal. And so I had to do a lot of digging. And after about 4 or 5 hours worth of work, calling the district court, tracking down the original lawyer, talking to the lawyer, talking to the lawyer's assistant, having them look up the case. I mean, I was able to get the warrant recalled, but it did seem like kind of ridiculous. He had explained it had been something from about 10 years before that had been long resolved. It was actually probably a mistake, just that before the case got resolved, he was to appear, I think, for some interrogatories. And so this is a real thing, and someone who didn't have the presence of mind to, or just have an attorney they could call up like that would likely have, had to get incarcerated. So I think it's a great bill and that we should probably pass it.
Hey, there you go. I appreciate that ringing endorsement. Now, I'll just say, look, another thing that I neglected to mention in the kind of my opening presentation is that this is also not an efficient way to collect, to find money and to actually, resolve that debt. It's not efficient. And so you'll hear folks speak to that a little later on about some of the ways that they can actually track assets and actually move forward with actually resolving those things. But so it's not an efficient way, but also, then again, being just honest, look, it's not about the debt, it's about the show cause, so, which is associated and attached to that initial failure to answer those interrogatories or appear. So just being honest with the committee of what the actual body attachment is issued for. Yep.
Okay. Senator West.
Thank you, Madam Chair. So, Senator Smith, I don't think I've ever seen as strong an opposition from the Maryland Judicial Conference to any bill as on this one. So let me just read you a portion of what they say. They say, if an individual knows that they cannot be arrested and brought to court to enforce the judgment, there is no incentive to appear. Further, there is no consequence for that failure to appear if the person cannot be forcibly brought to court to show cause why the individual should not be held in contempt. How do you respond to that?
So I would say I'd take exception to the characterization. I've seen much more strongly worded letters from the judiciary. But look, I think look what the underlying reason is. The reason is for small claims. And it's the policy choice here is, do you think that someone should get enmeshed and potentially incarcerated, arrested, because they have failed to answer adequately for small claims, and where there are other, and that's why I kind of alluded to this earlier, there are other more effective measures to track, gain that information, and resolve that debt, as opposed to being subject to potential incarceration and arrest.
Okay, well, I guess we'll hear those procedures later, but one more question for you. I think the assumption here is when the person gets brought physically to court, that the person goes to jail. But in my experience, the whole reason to bring them to court is to have them physically there so they can answer the questions that the person evaded answering by not going to the deposition in aid of execution. So I don't think we're talking about incarcerating someone, but merely literally taking their body and bringing it into court so they can answer the questions. What's the problem with that?
So actually, I will read these, but I think it's much more effective just being read by Maryland Consumer Rights, because I have actually anecdotes. I have like little vignettes of actual cases from Maryland here, which I'll just give to you. I'll walk over to you.
Okay.
But not to belabor the point, I think it's much more powerful from the practitioners who've actually dealt with and like held the hands of people that have been incarcerated and have these horror stories foisted upon them. But I have several vignettes that I can certainly give it to you in writing.
Okay, great, thanks.
Senator Castley.
So when we say small claims, that's small claims, this is defined in the Court and Judicial Proceedings article. That's those small claims, right?
Can you say that one more time? Sorry, I
Yeah,
couldn't.
it says they can't, it refers, in the bill, it talks about they can't be incarcerated for failure to respond to an order to appeal in court for examination and enforcement of a money judgment entered in a small claims action, right?
That's right.
Small claims action is as defined in the Court of Judicial Proceedings article, those small claims actions, right?
That's right. District Court has exclusive jurisdiction of 5,000 and under.
And small claims currently is 5,000 and under.
Correct.
So wouldn't this be more proper to just say you cannot use an examination to enforce a small claims action? Isn't that what this?
No, because I think you still want to have the ability to have that. I mean,
Why wouldn't everybody just say you don't have to do that? Why wouldn't everybody? I mean, there's a small claims judgment against me for $3,000. The other attorney says files for a claim, examination, age of enforcement. Why wouldn't I just say, not doing that?
You push it to the logical conclusion if this bill goes into effect is that you're going to have your wages garnished. And,
Right.
Once you start making some money, that's what's going to happen. And
No, I
you
get
had
it,
the
but wouldn't
opportunity
it be-
here to present evidence as to where you could broker a plan and move forward that way. So there is an incentive to cooperate, but in those instances, and that's why I think those vignettes are really
I'm sorry,
important.
what is the incentive to cooperate? Because I know that either way, I know what my assets are. You're the lawyer for the creditor. You don't. Why would I care to enlighten you? I could just pay it, or I can make you chase me. Why wouldn't all people in small claims action just say, don't bother, those.
Because there are some serious consequences if you don't resolve it through the system. And that, I mean, and to include, I think the most serious of which
other
is
means.
wage garnishing.
Right, but people who don't show up, they're gonna have to use other means, and people who, I mean, if I don't have the money to pay, and I'm not gonna come, you'll use other means. If I have the money to pay, and I don't show up, you have to use other means. So, this basically says, people who flaunt the court orders get an advantage, and people who don't, why wouldn't everybody get the same advantage? Just say, you can't use examination aid of enforcement. It puts the court, I understand where the court's coming from, either take this away from them and say, you can't use these things, otherwise you're giving the court a tool, examination and enforcement of a judgment. And the court says, you give me a tool, but it's meaningless because people just flip me the bird and walk away. Why wouldn't, it seems to me what we're really saying here is, just taking that away in small claims actions, you can't use examination and enforce it to collect a small claims action, then everybody's on the same footing, and nobody can flip the bird to the court, and there you are.
So there's the, I guess there's, you've got to get a compounding, yes, failure to respond, and then also the court order to make you say you got to do it. I'd say, look, again, they're just, the consequences of not adhering to the court order are still also there, apart from the fact that you just can't be incarcerated or thrown into jail.
Okay, but what is that? I didn't show up for the examination. There's no black mark on that, other than that I didn't educate the creditor. It's not like it goes in as a judgment against me. It just, you didn't show up. The court can't issue an order. They can't issue a body attachment.
You'll get the judgment, and you'll get your wages garnished. I mean,
There's already a judgment,
yeah.
because that's how you got to get a judgment before
yeah.
you get the examination. So the judgment's there, it's on the record.
Yep.
Judgment for $4,000, and now the attorney for the creditor is coming back in and saying, filing for an examination and enforcement of the judgment. But he knows when he does that creditor or that debtor can just say, not coming, and now you've wasted your money filing for that, because you had to file for that, you had to pay your attorney to go there. People don't show up, there's no consequences for it. No one's going to show up for these things. I mean, as a practical matter, once you say there's no consequences to it, and now you've made the court the court's now wasting their time because they're going through all this processing of examinations and enforcement of judgment, and nobody's going to show up anyway, and all you're doing is collecting fees for a worthless piece of paper.
So we're going back in, I guess, the cyclical argument here. All I just keep saying is that there are still consequences.
And I'm just asking to identify one, because either way, the creditor's going to go after anything they can.
And so, the ability, and I won't speak, the creditors will speak to the ability to kind of determine assets and other ways to access databases and such, but I still think, look, you're still going to get your wages garnished, you still got a judgment against you, there are still consequences. Just don't include incarceration or being the ability to arrest.
All right, thank you.
Okay, great. Some of these questions probably can be answered by the panelists. Can we turn to the panelists now? Are there any further questions
Sure,
of the
unless there are
sponsor?
further questions from the committee.
Okay, first we have Steve Sakamoto Wingo from the Consumer Protection Division of the Office Attorney General.
Good afternoon, Madam Chair, members of the committee. Steve Sakamoto Wengo with the Attorney General's Office, and we're here in strong support of this bill. In fact, the Attorney General was a prior sponsor of this bill. We just really think that this is an outmoded and outdated method of collecting debt, especially where we're talking about a small claim, which is less than the amount that could be exempted by the debtor anyway. There are other alternatives, as the creditors bar will be willing to talk about. And the Attorney General's office, he had a task force during the pandemic on access to justice, and this was one of the recommendations from that task force. And if you don't have a copy of the report, you can get it off the Attorney General's website, but there's a lot of good information in here. But it does, once again, affect poor people and minorities overwhelmingly. Once again, one of the things that we discovered during the task force is that the substantial majority of people in small claims actions don't show up. And there are a bunch of reasons they don't show up, because they can't get childcare, they can't take off of work, they just figure their judgment proved, so why bother taking the time to show up for this proceeding anyway? And, after the judgment's entered by default, if they're going to then, be receiving interrogatories or a notice of deposition in the mail, the same applies. I just don't have the time to deal with it. I can't be bothered. There are a whole bunch of reasons. It's not just I don't want to pay this debt, but I just can't deal with it. So we urge a favorable report and want to thank the chairman for sponsoring this. Thank you.
Excellent, thank you very much. All right, next we'll hear from Ms. Highland.
Thank you, Honorable Chair, members of the committee. My name is Kat Highland, and I'm here on behalf of the National Association of Consumer Advocates. NACA is a nonprofit organization made up of private and public attorneys, law students, academics, et cetera, whose mission is to promote consumer fairness. And at the forefront of that are issues related to debt collection and improving consumer protections on those issues. We've testified in favor of this bill before, many times in fact, and our members in Maryland have many poignant examples of handling cases involving individuals who were never properly served and individuals who were victims of identity theft who were picked up on body attachments and sometimes held as long as a weekend if they got to the district court at the wrong time while waiting to prove that this debt actually never belonged to them. So off the top of my head, I know of 2 consumer attorneys who have dealt with that issue in the past few years. And this is a problem that relates to the fact that debt collection isn't perfect, and the district court is the high-volume system through which a lot of cases are carried through. It's the method of debt collection. So honest consumers suffer from the fact that body attachments are still allowed in Maryland. In addition, as you've heard from the last speaker, this method is seriously outdated. You'll hear some great stuff from other people on the panel about the innovative technologies and how the industry standards have in fact changed to the point where interrogatories and aid of enforcement are not the preferred method, and they can also be handled by mail, so there isn't a huge waste of time. Finally, there is an argument to go to what we've heard from the Maryland judiciary, who we do respect very much, that this method is actually unconstitutional, or at least in the spirit of the Maryland Constitution to pass Senate Bill 452. The Maryland Constitution provides no person shall be imprisoned for debt except for child support and alimony, but we allow arrests and we're currently allowing detainment. So Senate Bill 452 would uphold the Constitution and we urge a favorable support. Thank you.
Thank you. Mr. Schlee.
Thank you, Chairman. Thank you. My name is David Schlee. I am the past president of the Maryland D.C. Creditors Bar, and I'm the current legislative aide. We worked on this bill last year along with the Attorney General Frosch and a committee on the opening of the courts and the COVIDs. We strongly support this bill. I'm also here to answer questions that I also know that Senator Castley and other people have mentioned about the process and the way it works. I will tell you right now that 99% of all collections and recovery takes place from a wage garnishment, secondary from a bank garnishment. Very little money is ever collected through the enforcement of those interrogatories. Secondary, over the last 5 years, and especially since COVID, interrogatories have not been done by almost every major creditor and have been barred by our national organization across the country. The reason being is that once you start that process, you do find instances where people will end up being incarcerated, and the PR and the social things that go on with that, most of the time those people, when they're incarcerated, don't pay their debt off, and you find out there are these horrible stories about $500 and somebody being lost in Baltimore City over an entire weekend. And for those practical purposes, our organization and our national organizations have come to the conclusion that this process is not one we can continue to support, and we find that we are in favor of this bill. I'm also here to answer any questions on the practical aspects of the process, since I think I'm the only one here who's ever done a bank garnishment or a wage garnishment, to let you know how the legal process works with that and how things have changed since post-COVID. Thank you.
Chair Smith and distinguished members of the committee, thank you for the opportunity to be here. My name is Amy Hennon. I am the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyers Service. MVLS connects low-income folks with volunteers that assist them with their legal cases throughout the state, and approximately 30% of our clients have a consumer issue. You all have my written testimony that describes the scenario of my client Jeremy, but I want to get into a little bit about how folks like Jeremy wind up with MVLS. And almost all of the clients that have a body attachment come into us through one of 2 programs. One is our workforce development program, where we're providing wraparound legal services to folks that are in job training programs, very much like the one Judge Pastore described that's happening in her court. Secondly is through our human trafficking prevention project, where we're again providing wraparound legal services to folks that are at risk of human trafficking or escaping human trafficking. Almost all of these clients did not know that they have a body attachment against them. It did not compel them in any way to appear in court. They didn't know that it existed. The first time they learned of its existence is when they sat before me or before one of my colleagues and learned that they had a body attachment against them. There are plenty of horror stories that exist when people actually get picked up on body attachments, but really it is not an effective legal tool. It's not helping the system be more efficient. It's not helping ensure that these folks are paying debts that are potentially owed. But rather it just creates a hurdle that potentially keeps them in poverty and keeps them from being able to move on with the next step of their life until they have a lawyer who's able to help remove that process for them. And so for these reasons, I would urge a favorable report on this bill that we have testified favorably on before. And I will tell Mr. Schley that I actually previously was a debt collection attorney in a former life, and it's definitely not an effective tool. Thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of the Maryland Consumer Rights Coalition, MCRC, and we work on economic rights and equity through research, education, organizing, and direct service. I'm here today in strong support of SB 452, and I want to thank Chair Smith for introducing the legislation. As Senator Carter mentioned, legislation was introduced and passed in 2014 by now A.G. Frosch when he was a senator and chair of this committee. That bill did make improvements to the process of these body attachments. But just to be clear, between 2015 and 2018, a report looked and found that on average, there were 255 Marylanders each year who had arrest warrants taken out against them. And to be clear, 77 people were jailed. So people are both being arrested and taken into court and jailed in court for this process. A couple examples, and I'm happy to send this to the committee. There was a Brian B. from Essex in Maryland who was picked up and arrested and jailed, and the amount of the bail was set at the amount that he owed the debt collector, which he didn't have. He couldn't afford to pay it. So he was in jail for 2 weeks while his mother tried to raise the money to get him out of jail. Last year, a woman testified who was picked up and had to turn herself in. Montgomery County woman, because of a dispute with her HOA, she didn't receive the service because of problems under COVID of people getting mail, and she was handcuffed, taken to court in Montgomery County, and in jail for a number of hours while she had to get care for her child. She was a single mother during the middle of the pandemic. We also have other stories of folks from Prince George's. I will simply tell you why we think this should not be used anymore. First of all, it's unnecessary. Creditors and consumer advocates agreed this is an outdated practice from another era, and we have new tools and ways to get answers to those questions to be able to pursue people for debt. Secondly, it creates a two-tiered system of justice. As we said, oftentimes the amount is set at the amount that someone owes the debt collector, and if you can pay it, you're released. If you can't, you are in jail. It criminalizes poverty. It creates a vicious cycle of poverty because, again, if you are in jail over the weekend, you may have an hourly wage job which you can no longer go to. You may have to struggle to find care for your child and pay someone for that while you're in jail, all of which makes it more difficult for you to pay your debt because of those reasons. You may lose your job if you're in jail for a weekend at certain places. It does not serve a constructive purpose. The individual is not violent, nor are they a danger to the community, but they could experience real harm if this is an issue. And in the middle of a global pandemic, putting someone in jail is also a public health issue. It's a public health risk to be picking people up and jailing them because they owe money to a bail bondsman or a landlord or a county. And it's not a good use of taxpayers' money. I will simply say our judges and our police have a lot of important things they do, and I don't think this is a good use of their time or energy or money to pursue someone for these kinds of small debts. So for all of these reasons, we are here today asking for a favorable report of SB 452, and I'm happy to answer any questions.
Thank you, Mr. Chair. Just help me understand the process. If I have a claim against you and you don't show up and I go to court, is the award automatically made in my favor?
I am not a lawyer, so there are probably people who are better here to answer, who can answer that better than I am. But oftentimes people of the people that we see that this happens to, about 2% of them are represented by a lawyer, so often there's a judgment against someone if you don't show up.
Is that, you agree with
I'm
that?
like looking to.
Oh, no, and I was looking at David Schley, too, because I know there are instances where the creditor's attorneys don't request a body attachment, and the judge feels that this is the only method they have to impose. So I think there's some tension right now, because you do have to request it. It's not automatic, but it can be if that particular judge thinks it's appropriate.
Past the body attachment, which I'm trying to get my head around, just how do I get my money if you owe me money? How do I get it? What's that process?
So I'm going to do it in a layperson's way, and other people can add in.
Yeah.
You are a landlord, and I owe you money. You go, or you are a credit card owner, whoever, bail bondsman.
Yeah.
You go to court. They find against me. They say, yes, I owe you the money. Now, it may be that I'm like, I don't have the money. But then you have a lot of tools at your disposal. You can get my wages garnished.
But wait a minute, the example you just cited assumes you came to court. I'm saying
Yes.
if you don't show up, I'm automatically the winner, is what you're saying? And then there's a next step by which, through some kind of systematic process, either your wages are garnered or something else to facilitate me getting repayment
That's
based
right.
on that judgment. Is that fair?
Most of the time.
Yes. And I think the goal of this is not to say people don't pay their debts. We're saying there are other, I mean, I don't think the creditors bar would be with us if that was the case. There are tools we have to get people to repay you. We're simply saying that arresting someone and jailing them is nothing that's needed if it was ever needed.
I agree, it
Yeah.
doesn't get my money any faster.
Could we have Mr. Schley answer that?
Thank you.
Because that's the.
We can definitely have Mr. Schley
Because
answer
if
that.
you get the default judgment if you're not there, right?
Yeah.
So
Yeah, so
then go, yeah.
Yeah, you file suit, you have a right to answer, you got 15 days to right to answer. If you don't answer and your evidence is correct and everything is there, the judge looks at it, they enter a default, or you have a trial if you do answer. So we have a judgment at that point. You got 30 days to appeal after that. Okay, so you got another 30 days. You got notice, you have all of that. Then at that point, you can place lien on property, which is one thing, and it actually happens automatically in Baltimore City. And then we go out and we look for, do the people have jobs? Because that is obviously the best way for us, is to do a wage garnishment. And then we also find out if they have a bank account, and then we would do a bank attachment. Okay? The reason we don't do the enforcement of the interrogatories is, one, most people who show up they don't have any money. They come in and they just say, look, I don't have any money. And really, they satisfy the interrogatories, but it's basically a waste of time. But the second part is when you start that process, you can't stop it. So if they don't show up, it goes to a show cause. At that point, it's out of everybody's hands. The judge could decide, they didn't show up for the show cause, I'm going to put a body attachment on them. So right now, effectively, everybody that I'm aware of, anybody who is of large size or volume, landlord, tenants, everybody, no one's doing the interrogatories because they do not want to have the situation where they get to that body attachment. Because the last thing you want to do in the middle of COVID is be in the newspaper having Marceline talking about debtor's prison. So that's the reality of what's going on, especially in the post-COVID world.
Got it. Thank you for that.
Hopefully that helps you. I don't even know if I talked to you.
Thank you
So
very
you
much.
say like there's an optics problem, obviously, but there's an efficiency problem. It's not as efficient. And so just because it's piggybacking off of your question is, since you don't use these interrogatories in aid of execution, because it starts this process that you can't really stop if that person doesn't show up. But also, there are other better, easier methods to find out the information you need to pursue, resolving the matter. So just my question then is to kind of talking back to what Senator Cassidy was asking me, because we're going back in circles, was that if you just got rid of the requirement for these interrogatories, what if you just got rid of that? Would that help, in your opinion?
I don't think it makes a difference at this point.
'cause
Practically,
you
for all intents and purposes, it is over with. The only people that are using those interrogatories now would be very small, single, anybody who doesn't have to hire an attorney, which would be not a lot of people, because in most cases, you'd have to have an attorney even if you're under, $1,500.
It takes away the underlying reason to have the show cause and
Right.
then the body attachment.
Correct.
So that's
Yes.
my question, yeah. Got it, thank you. Senator West, sorry to interject.
Thank you, Mr. Chair. So let's start, Mr. Schlees, let's start with that.
Back up.
So right now, what this bill states is that a Maryland court has no power to punish contempt of the court. Wouldn't it be better, in your view, instead of enacting a statute that says the Maryland court has no power to punish contempt, to get rid of the interrogatories and the examination of inative execution, which give rise to the body attachments which this bill is against? Wouldn't it be preferable for us as legislators not to tell the Maryland courts that you have no power to punish contempt? Wouldn't it be better to abolish the examinations in inative execution or the interrogatories that give rise to the contempt in the first place? You see what I'm saying?
Yeah, so, Senator, I know that we've asked the legislature to take a look at this and the practical uses of it, because it is an outdated process, and the Rules Committee hasn't taken us up on that. So
Okay,
I
well,
don't.
this isn't the Rules Committee, this is the
No, I
General
understand that, but
Assembly.
I'm saying that would be where you could get the judiciary to look at that.
Right.
I'm not, it's probably a little bit above my head in this, I mean, I'm just a practical lawyer here, about how that, do I think if you got rid of interrogatories?
Inative execution.
Inative execution under $5,000?
An
I don't think it
examination,
makes a
inative
difference.
execution.
I don't think it makes a difference.
Right.
Yeah.
So it would accomplish the same thing that this bill strives to accomplish, correct? No body attachments. Because if you don't have the
Correct. 'Cause you wouldn't
interrogatories,
start the
you don't have the
process.
examinations,
Correct.
you have no body attachments.
Correct.
Okay.
Senator West's question is mine, my same question fashioned a different way. That's
Right.
exactly the same question. So
Exactly.
so can we get one of the other attorneys to lean in on this? Because I think it could be a potentially more elegant solution without touching the contempt of court issue.
Senator, I don't, to come at it a couple of different ways, I don't, I don't think this is taking away from the court the ability to hold somebody in contempt of court. It's just taking it away in this one particular, it's just taking it away with regard to the person showing up or not showing up for the show cause hearing.
But that's what this is all about, isn't it?
Yes.
So,
But
Are we arguing the same thing in reverse? Like seriously, like, because if there's no requirement for the interrogatory,
Right.
then there would be no
Body
need to
attachment.
have a body attachment to compel their presence to answer an interrogatory that doesn't exist.
Right. I think
I'm wondering
the
if-
chair and I are in total agreement on
Yeah, but I'm
this.
asking the question from the folks that are in the field
Yeah,
on this.
right.
Yeah.
could you restate the question then?
Sorry. So I think we're saying the same thing, is that if there's no requirement to fill out these interrogatories, then there's obviously there would be no issuance of a body attachment or show cause. There's no show cause for a requirement that doesn't exist. So would the more elegant solution be to just get rid of the requirement to answer the interrogatories, or just do away with them, so that there's no underlying reason to have people not show up to answer something that's not being used anyway? In a small claims estimate, yeah. Of course. It's all limited.
I am not against written interrogatories or oral exams those and oral exams being removed in small claims actions. I think that is a perfectly reasonable, I think it is a perfectly reasonable solution in the sense that, again, these are small amounts that if the person had the ability to pay, they either would have paid them or the person would have located through one of the many enforcement options in terms of finding out where folks work and finding out where folks bank, because there are all of these fancy computer programs that allow people like Mr. Schlee to find this information. They would have found that before, and so I don't think oral exams or interrogatories in aid of enforcement are a useful process.
Okay, because then you get away from the judiciary's opposition.
Right.
I mean,
Yes, I think that's right.
But I want to make sure that's copacetic with,
And just
if there's something we're missing.
Just to, what, did you want to say something?
Yeah, let me say something, because I
Okay.
think I want to clarify something. Kat, sorry about that.
It's okay.
I do think the counter argument to that is if you do stop the body attachment, you could possibly see some people using those interrogatories. Even though you're right, a lot of people won't show up, some people will answer them. So people will start using that tool. It just won't go to that final result of the body attachment. So I know, for instance, in landlord-tenant cases, they had a bunch of bad publicity about 2 years ago and about these cases coming up. And they were going to just stop doing the show causes and the body attachments, but they couldn't get the court to stop doing it. So they ended up at that point, just stop doing it in total. So,
But I think what
there's an argument that you could end up having
But
the
what we're
possibility
talking
for them to
about-
use the interrogatory.
What we're talking about here, I think, is passing a bill which would say there shall no longer be interrogatories in native execution permitted in Maryland, and there shall no longer be examinations in a native execution permitted in Maryland. So you wouldn't have any more interrogatories or examinations in native execution in small claims cases.
Well, just to offer a couple different perspectives, because I think this is actually a really interesting conversation that's probably worthy of a little bit more discussion. District court's supposed to be neighbor-to-neighbor court, right? So what strikes me as something we might want to consider as an option is keeping the option still there for my neighbor who sues me because they don't like where my fence placement is to have that neighbor-to-neighbor unrepresented method to get more information out into the open. So in that example, you don't need to take away the interrogatories and aid of enforcement just because there's no arrest at the end of it, right? You still have it there as a discovery technique. And it is true that sometimes, and I know Amy sees this too, people come to court who do want to talk to the other side. It's an opportunity for them to get through, maybe if they haven't been able to get through the long voicemail system of the debt collector's service, or, they're always, limited for time to make that call, they do get a face-to-face opportunity to do things like enter into payment arrangements with the other side, because they're guaranteed that the other side is actually going to be at court that day. So there's still a reason to have it as a device, even though you don't have this so-called deterrent factor there anymore at the end for, I guess, the more institutional rollout, which isn't even being implemented right now. I don't see the need to take away the actual device, but the final thing I just wanted to mention is we don't actually have formal discovery in these cases.
Correct.
We don't have any interrogatories for small claims to begin with. So it is kind of unnatural that we do have interrogatories at the back end of the process to get more information when we don't even use them for the claims that are under 5,000. So I think there are a couple of pros, a couple of practical ways in which we still could have the interrogatories, but overall the trend is going away. So for what that's worth.
I think we're there. But let me address what I believe is the huge hole at the middle of this issue. And that is, a number of people talked about how the current system is outdated, how there are alternatives, how there are new tools. Bottom line is, I think Mr. Schlief said, 98% of the money that is collected to pay off these small claims, it comes as a result of wage garnishments and bank garnishments. So the whole purpose of interrogatories, native execution, and better yet, in my experience, is examinations in native execution, is to find out where the debtor banks and where the debtor works. So if we don't have interrogatories or examinations, how do the creditors these days, you say there are new techniques, and I did some of this 40 years ago. I haven't done it since. What are the two new techniques that are used by the creditor community to ascertain where the debtor works and where the debtor banks?
So there is several products out there through the credit bureaus. One through Experian, that when anybody does a background check or they have to do reference checks, they take all of that information and they combine it up together and then resell it into a database.
But for an impecunious debtor,
No,
those
it's for
names
anybody.
show up in these databases?
Anybody through the credit bureaus right now, for $20, I can find out, as long as I'm doing something in enforcement of a judgment. I can't
Right.
just do it
Yeah.
randomly and find out where you are.
Right.
But if I'm doing an enforcement of a judgment, they take those ADPs and all of those big processing companies, they all put their metadata together, and I know we can run the file every day. I'll know if somebody starts a job the next day. I'll know how much they make.
In what percentage of the cases do you come up short and can't find where the person is working or where the person is banking?
I can find where they're working, but they might not be working, so there's two different questions
Yes,
there.
yes, right.
So, right now, I'm getting about a 25% hit rate.
25%, so the 75% you can't get any information?
Correct, but again, they could be a 1099 employee, they could be a real estate agent, they could be, they might not be part of those services. And
So
then,
if I'm a
by the way,
creditor-
that money's also protected.
If I'm a creditor and want to keep my money safe from you and open a bank account in the Farmers Bank of Selbyville, Delaware, would you come across that through these data searches?
Yes.
You would?
Yeah, we would know. There are 3 other services out there that use different database methods to compile that data.
Okay. All right, thank
I
you.
mean, it's similar to what you would see on Facebook and everything else.
Is that a subscription service, or is that like a one-pop deal, like
You,
month to month?
well, you have to be, first thing you have to have, you go through actually a process to be verified for it, and you pay per hit. And they guarantee it's verified.
Senator Heddleman.
Thank you, Mr. Chairman. I wonder, Ms. Henman, Hennon? I'm
Yes.
sorry. You mentioned that you had a number of clients that didn't even know they had a body attachment. Can you talk a little bit about how that is? And we're talking about, so you just said that 93% of the time you get these, you find somebody. So we're talking about a very small number of people, right? To begin with.
So the folks that we encounter, and again, I'll mention that they come in primarily through these programs where we're providing services to folks that are sort of kept out of the traditional economy. They don't have jobs that can be found. They're either not working or they have some sort of underground employment previously. And for all of these folks, they almost never either remember or actually didn't receive the summons for the underlying case. They didn't receive the summons for the oral exam. They didn't receive the summons for the show cause. It was in a number of clients that I've spoken to where I've wound up filing to quash the body attachment. I was able to demonstrate, for instance, that my client was incarcerated at the time that the body attachment, that whatever it was served. And so for all of these clients, there isn't anything to be found.
Is there any requirement of affirmation of service?
So there is, but if you serve on an old address and you believe that you're serving on a co-resident, if the process server believes they're serving on a co-resident, that's what they will swear to.
Okay.
They have to prove proof of proper service for this
They
one.
do. Okay.
This is, they are required to prove proper service, and yet proper service does not occur.
Absolutely correct.
Okay. Okay, thank you.
Okay, seeing no further, thank you all very much.
Thank you.
And with that, that'll conclude the hearing for Senate Bill 452. We'll now move on to Senator Edwards, the Senate Bill 629.
Thank you, Mr. Chairman. Is it okay if I bring my one-person panel up here? Mr. Dwayne Yoder, he signed up, I believe, to speak. Dwayne is an old friend, grew up in the same town, went to school together, statewide and nationally known for his housing expertise and community action expertise, and asked me to introduce a bill, and it's hard for me to say no to him. So he's the expert I brought along. You have any questions, plus whatever he has to say. But thank you, Mr. Chairman, members of the committee. I'm here to ask for your support on Senate Bill 629. At the height of the pandemic, we feared that countless families would be evicted from their homes as a result of lost income. Thankfully, the action of the General Assembly, Governor Hogan, and the federal government have helped many families stay housed and allowed many property owners to be paid the rent they were due. We're not out of the storm yet, but the work of county governments, community action agencies, United Way, and numerous other local assistance groups has had a great impact. One of the things this crisis made clear is that we do not have a uniform system for collecting and reporting data related to evictions throughout the state. In different jurisdictions, sheriff's offices report different information about executed evictions. The state court system has made improvements in this data reporting, but still only provides data at the county level, and the data is at least a month old before it is available. It would be nice to know where evictions are most concentrated in our state and who are being evicted. The state cannot make data-driven decisions about which communities to target with outreach of assistance without real-time data. This is an urgent need as the pandemic continues and the state distributes hundreds of millions of dollars in rental assistance. This kind of data would also allow rural communities to engage with local organizations to provide local solutions for property owners and tenants. I know the courts may say they still
they're still getting the new electronic system up and running in every county. There may not be the capacity to report the exact same data in every jurisdiction at this very moment. But we have to start somewhere, and I believe that when we start seeing data from a handful of counties and start seeing the potential of what policies and programs can be impacted by having the data, everyone will want to make sure we have a robust system. We will do better by all Marylanders who put their faith in us as lawmakers when we have data to support the decisions we make. I ask you to give Senate Bill 629 a favorable report. And if you have any questions, I'll ask my good friend to answer them. Go ahead.
Well, thank you, Senator Edwards. What he didn't tell you, we did grow up in the same small town of Grantsville. He was in town, and he was, in my mind, one of the townies. I grew up in a Mennonite Amish farm right outside of town, and I was, in his mind, one of those Dutchmen. But we do have a long history. But thank you, and Mr. Chairman, my name is Dwayne Yoder. I serve as president of the Garrett County Community Action Committee. And thank you for allowing me to testify in support of 629. I want to thank Senator Edwards for sponsoring the legislation. From my point of view, this information that we collect will better help us understand and respond to the problems that arise when families and individuals are evicted from their home. It is also needed to better target our social safety network programs and services that we administer. Garrett County Community Action wears several hats. We're a housing developer and a landlord. We have over 700 affordable units that we manage, possibly the largest landlord in Garrett County. We're also a provider of an array of services designed to help families stabilize and prevent homelessness. 888 renters were assisted in 2021. 80 were sheltered in motels or a homeless shelter. 163 were evicted, and we were able to find permanent housing before they became homeless, and 243 were assisted with prevention services. I cite these numbers because from a housing developer, it's important to know who's being evicted, where they're being evicted, and what the nature is. It's also important as a service provider to structure our programs in a way that respond to who's being evicted. The data information, I believe, that it would be collected from these from this system and this bill would focus directly on that. And I urge the committee to report favorably on this. Thank you very much.
Thank you. Questions for the sponsor or his witness? Senator Heddleman.
First of all, thank you for your service and for all the work, important work you do in Garrett County and beyond. I just read the testimony of the judiciary, and they say they can't do this because we still have the antiquated system of collecting all this information by paper, which is mind-boggling. But I just want to give you an opportunity to respond.
And I don't know the answer directly. I think some of the people who may follow me have a better response. But I would start with what Senator Edwards said, is that we have to start somewhere with a question. Otherwise, we'll never get there. And I think the starting point is this bill. Thank you.
Thanks.
Thank you both for your testimony. Appreciate it. Next, we'll have Deb Seltzer, Claudia Wilson-Randall, and Vicki Schultz.
Mr. Chairman, I'll probably leave because I have another hearing.
Of course.
Thanks.
Whomever would like to go first. At the podium, please.
You want to go first? Good afternoon. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network of Maryland. We serve nearly 200 members across the state. Most of our members are on the front line of distributing eviction prevention funds and social services throughout the state. I want to just emphasize the need for the need for this bill, Senate Bill 629. Communities are seriously harmed by evictions in Maryland. Eviction and foreclosure are where community decline begins. This means higher costs in health, police, fire, schools, and community safety net programs. Currently, local and state governments can't answer simple questions about evictions in the state. Where are evictions most concentrated? Who is at most at risk for being removed from their home? Decision makers cannot make data-driven decisions about which communities need rental assistance most. This is an issue during the pandemic and beyond. In my experience working with community school coordinators across the state of Maryland, a considerable amount of time is spent on addressing housing instability. Schools where 20 to 30% of the school population are moving during the year cannot be successful. Communities are seriously harmed by people being put out of their home. If the judiciary in one of the wealthiest states in the country cannot collect data in a timely and effective manner for analysis and intervention, then we need an alternative measure in 2022. Government dysfunction has effectively blocked real-time data. And at what cost? Maybe 2 full-time FTEs? What if the problem were impacting other populations? How would the legislature respond? What if the court system could only do this for, say, 15 of the 23 counties in Maryland? I just want to close by saying the health and human development consequences of evictions for children, adults, elderly are long and lasting. Maryland must find a way for an eviction database to better understand and solve housing instability throughout the state. I ask for your favorable report of Senate Bill 629. Thank you so much.
Good afternoon. My name is Vicki Schultz, and I'm chair of the Maryland Access to Counsel and Evictions Task Force set up by the legislature, and I'm also here on behalf of the Maryland Access to Justice Commission, on which I serve. Both the Maryland Task Force and the Access to Justice Commission strongly support SB 629, which would collect and make available timely and important information about where evictions are taking place across the state. Currently, data about evictions in Maryland is limited. Current data does not provide the level of detail needed about eviction cases and outcomes. It's not produced in real time, nor is it well integrated with other sources of available data. This bill would begin to fix that problem by requiring basic data sharing between the judiciary and DHCD regarding evictions. Specifically, the bill would take an important step toward integrating data about eviction outcomes with other data already kept by DHCD about housing trends, rental assistance, and other homeless prevention resources. As you know, the task force is responsible to evaluate the services provided through the Access to Counsel and Evictions Task Force and make recommendations. Without effective data, however, the absence of that data hampers our efforts. Additionally, the lack of real-time data limits our ability to identify eviction hotspots, target outreach and education efforts, assure equity in the implementation of this program and others, assess and adjust the program as it's implemented. SB 629 will not only improve the ability of the task force to do its job, but it will assist decision makers like you, as well as those in the executive branch, to make good choices about how we can prevent evictions in the future. Therefore, I respectfully urge that the committee report favorably on SB 629. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Deb Seltzer. I'm the Executive Director of Maryland Legal Services Corporation, which was created by the General Assembly in 1982 and last year named as the administrator of the Access to Counsel and Evictions Program. As administrator, we will use eviction data as a key factor for funding decisions, especially during the program's implementation period. The statute requires MLSC to prioritize implementation in jurisdictions that have provided their own resources for eviction prevention legal services. But timely data about eviction action types with detailed locations will help us determine other aspects of prioritization. Data will also be key for tenant outreach and education required in the Access to Counsel statute. The outreach is a vital piece of the program because we know that, while not possible in every circumstance, legal services are more effective if tenants are connected with counsel before their court date. In order to make that connection, MLSC will seek trusted members of the community to be messengers, and this data will help us know which communities to target first. As implementation proceeds, MLSC will seek to compare court data with the large amount of data that we already collect from legal services providers, which includes information about level of service, county of client residence, client demographic information, recruitment and training of pro bono attorneys, major case benefits, economic benefits to tenants, and more. We will also look to add additional data points under this program, including more specific questions about eviction action type and case dispositions. Comparing this data to court data will help us further pinpoint areas of need. In short, additional data will help the Access to Counsel and Evictions program be more efficient and effective, and we urge a favorable report. Thank you.
Good afternoon, a long afternoon I trust it's going to be, Senator and Mr. Chair and members of the committee. I'm not going to repeat the comments of some of the previous folks to testify. We presented our written testimony. And of course, we would, by we, I mean legal aid, my name is Gregory Countess, with Maryland Legal Aid, would benefit from this data for the very same reason that the last speaker spoke about. That is, it would enable us to target our resources, because we don't have enough attorneys to represent all of the people who need assistance. And even if the Access to Counsel bill is fully funded, there's still other areas of law where we are responsible for providing representation for poor people. And that gap will still be there. However, in sitting in a hearing last week on Senate Bill 384, nothing pointed out to me the absurdity of the present situation we find ourselves in, but the competing testimony by the landlords and by the tenants about the length of time it takes from filing to an eviction. And we had one landlord come out and say, or testimony say, it's a year. The next day, over in the house, it was 6 to 9 months. And I can tell you that in observations by our attorneys, in many cases, particularly on the Eastern Shore, it takes 9 days to get a case heard and less than a month for a person to be evicted. What's the answer? The answer is we need data so that we can answer these sort of questions. You can make the decisions that you have to make, and we can send our resources to places where people are in need. And for that reason, we ask for a favorable report on Senate Bill 629. Thank you.
One question. I thank you all for coming. I really like this bill as we seek to get more metrics so we can make fact-based, data-driven, informed decisions. My one question is, I was just curious, and you brought it up, you said something, I think it was you, who is at risk is what we want to determine by getting some of this. And I was kind of thinking, should we take a deeper dive and identify, race as a part of some of the data we collect, or as I understand the way census tracts are formed, can we interpolate and get that same level of detail? Anybody can answer.
So I would just say right now, we're at zero. We don't have anything. So
Right.
we would like to get to the point where we've got something, and that we are then interpolating that race and income, because that can be done through census tract analysis.
That can. Okay. Thank you very much. Appreciate it.
unless anyone else has questions, as a practical matter, just for the judiciary's concerns, just, can you help us walk through, because I think we all like the bill, we all want more information, but just practically speaking, as MDEC comes online, a lot of the records are still housed in paper format. Just how do we, we all want to make this happen, but just practically, we're stumbling here, and I think the judiciary just.
Absolutely.
Yeah.
I certainly understand the position of the judiciary, but I would say that there is data. Data is not kept in its best form. Certainly electronic data is what we're moving toward, and I know the judiciary is working for that goal. But there is data kept. Right now, it's a little cumbersome. It's on spreadsheets, Excel spreadsheets, but that is data. It may not be the best way to collect data, but we have some data. And I think the key here is that articulation and integration with DHCD data. DHCD is in the business of really looking at housing trends and, again, providing homeless prevention services. So there is an opportunity, if that data is shared, and it can be. I understand there was some concern raised in the House about every 2 weeks. I think there's openness to talking about what a reasonable time period is so that it works for the judiciary's processes, but these can be produced. The sheriff actually has to serve these warrants, and therefore, and they get this information. We understand that it's provided in Excel spreadsheets, and the judiciary produces those reports after the fact. We just need some more granularity focused on these 2 points. Again, it's a modest step toward eviction data. It's not a big leap, but it's a step that we're ready to take, and I think the judiciary would be able to accomplish this, notwithstanding their current objection.
All right, well, seeing no further questions, thank you all very much. Thank you.
Thank you.
Thank you.
Thank you. And we have DePaul Nibber and then Grayson Wiggins.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is DePaul Nibber, in support of representing the Maryland Association of Counties in support of Senate Bill 629 with amendment. We echo many of the sentiments that you've already heard with respect to how important the data sought by this bill is. That said, our county administrators have been at the heart of administering the Emergency Rental Assistance Program, and so we would want them to have more direct access to this data than is currently included within this bill. So we have a small amendment within our written testimony to reflect this, and so we would urge a favorable with amendments report to include this bit of language. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. We are also favorable with amendments. We want to first commend the judiciary for the work that they are already doing. We see monthly eviction reports come out of their office regularly. Members of this committee certainly know that I love data. I always talk about the data. It's how we know that there's been no eviction tsunami after it was discussed at length early in the pandemic. We do have an amendment. As we looked around and said, what kind of data do we still need? What kind of data do we want more of? One thing that jumped out at us was that we don't have much data from legal service entities. So entities that receive state and federal funding to provide eviction defense. We lack data on the types of cases in which they provide representation, and so our amendment would simply ask that they provide reports on the types of cases and the dispositions, et cetera, the information. Thank you.
Yeah, actually, it's for the MDEC representative, I'm sorry, the MACO representative. You step down real quick, just real quick. So I mean, real quick, the judiciary says, hey, look, we're developing currently the only thing that they don't have it's not in MDEC is landlord-tenant actions. It's all paper. Of course, if that's in MDEC, then we've got thousands of people all over the state inputting data into the computer system, not just the court, but everything's put in data. So they're working on a system which, once all that data is in there, it should be fairly easy to take fields and create reports. But the big problem is, the major jurisdiction that this legislation is probably targeted is Baltimore City, and they're not even on MDEC yet. They're way behind. I don't know when they're going to come on. Does MACO have any proposal to help to accelerate MDEC implementation in Baltimore City?
Unfortunately, when we chime in on a piece of legislation, we look at how it's going to impact all counties, and so we wouldn't look at a piece
All your
of
other counties, pretty much, I think Prince George's is in MDEC too. I'm not sure. I know Montgomery's up now. Everybody, I'm not sure Prince George's. Baltimore City, we know, is definitely not. But as far as taking this stuff to data, that's the big hurdle we got for the judiciary, because they're already working on a system to put landlord-tenant in a posture where it would be a fill in the form, and then you can just extract data out of that, and they don't have to put the data in. Every landlord is going to be putting the data in. Every lawyer is going to be putting the data in. So data input, of course, is hugely time-consuming. But we don't have. But the city's not even, as far as I know, isn't even close to becoming MDEC ready. Thank you. Appreciate it.
All right, thank you both very much. And with that, that'll conclude the hearing for Senate Bill 629. We'll now move on to Senator Young. Senator Young, thank you very much for your patience. We have Senator Young with Senate Bill 649. Welcome back. You missed us so much you hung out for half the schedule here.
Spend the afternoon with you. Thank you, Mr. Chairman and members of the committee. I think I can do this in 1 minute. Senate Bill 649 directs $15 of the civil marriage fee to Heritage Frederick. It just affects the fees from civil marriage ceremonies performed in Frederick County by the clerk of the court. The clerk of the court currently charges $25 for civil marriage fees. $10 goes to the county general fund. $15 stays with the clerk, which we are redirecting to Heritage Frederick. Heritage Frederick, along with preserving and collecting historical documents in the repository of Frederick County, they're also the repository of Frederick County marriage licenses. Frederick County delegation supports the bill. Senator Huff and I are jointly sponsored it. Frederick County Council, Frederick County Executive. The clerk of the court has no objection and there's no opposition, and I ask for a favorable report.
Excellent. Thank you very much, Senator Young.
Thank you.
Seeing no questions from the committee, that'll conclude the hearing for Senate Bill 649. We'll now move on to Senator Zucker. Senator Zucker with Senate Bill 662. Welcome.
Thank you very much, Mr. Chairman, distinguished members of the Judicial Proceedings Committee, Vice Chair Wallstreicher. For the record, Senator Craig Zucker here, presenting Senate Bill 662. This is just dealing with access to counsel. As you all know, it's important to make sure that people stay in their homes, especially during these challenging times. This is just a creative way to actually fund access to counsel this year. We had, by law, required the governor to fund access to counsel. This bill was introduced, Mr. Chairman, prior to the governor's budget coming out. The governor did include $5.4 million, so there should be an amendment in your folder that is $6.4 million, which is the difference. It's basically a fund swap. It's a transfer. That way we can do it in fiscal year 23, so it takes effect immediately. And with that, I'd be happy to answer any questions.
All right, excellent. Thank you very much, Senator. I'll now bring up your panel.
Yeah.
If we could have Ms. Seltzer, we got Matt Hill up there, Katie Davis, Grayson Wiggins, and Vicki Schultz still here. Yeah. I think we've got room for Nick Katz.
Yeah, there we go. Good afternoon, Mr. Chair. Again, for the record, Matt Hill, Public Justice Center. I don't have too much to add to what Senator Zucker said. I just want to point out that this committee last year passed Senator Hedelman's excellent legislation, and that there is a 3-year period in which this legislation needs to be implemented, so that at the end of 3 years, the legislation says that all limited income tenants shall have access to legal representation in eviction cases. Why? Why is this important? An $11.8 million allocation, so 5.4 in the governor's current budget, plus another 6.4 from this bill, would help over 9,000 families avoid eviction. That is huge, particularly in the middle of the ongoing pandemic. That's 9,000 families who won't have to lose their belongings, won't have to change schools in the middle of a school year, lose their job because of disruption in their lives, or even become homeless. Legal representation is a proven, cost-effective means of reducing disruptive displacement and eviction cases. One recent study said 92%. In the last 6 months alone, just 4 legal services providers in Maryland have represented 1,284 families and had an 88% effective rate in preventing disruptive displacement and evictions. The governor's $5.4 million is not enough. Much of there was an expansion of legal services with new federal funds by local jurisdictions, and that expansion was about $4.4 million. That funding is going to run out, and so unless this committee acts, the $5.4 million is really just going to keep us at the status quo. This legislation would bring us above the status quo and really push us toward implementation. I'd point out that over 90% of landlords are represented and over 90% of tenants are not. This legislation helps that first phase of implementation in balancing the scales. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair. Again, Deb Seltzer with Maryland Legal Services Corporation. We are strongly in support of this bill that would help to jumpstart the Access to Counsel program. The Abandoned Property Fund has been a historical source of funding for civil legal aid in Maryland. This would continue that trend. So I don't want to repeat too much that Mr. Hill just said or that Senator Zucker announced, but I would just note that in my written testimony, there are cost estimates for the program that are built on several assumptions related to the number of eviction filings, the number of tenants who end up being eligible for representation, and the need to phase in this program over time. As implementation progresses, we will be constantly assessing those assumptions so that we can adjust as necessary. So MLSC urges a favorable report on Senate Bill 662. Thank you.
Good afternoon, Chairman, Vice Chair, and committee members. Thank you for the opportunity to testify. I'm Katie Davis, the Director of the Pro Bono Resource Center's Courtroom Advocacy Project. And as the pro bono arm of the Maryland State Bar, PBRC is in a unique position to attest to the fact that if properly funded, the Access to Counsel and Evictions Fund can be used to allow members of the private bar to provide representation for tenants as well. So doing so will not only benefit the tenants, but it also benefits the attorneys themselves. We support Senate Bill 662 because it provides a straightforward way to begin this process of funding to make this possible statewide. So in May 2017, with a grant from the Maryland Judiciary, PBRC launched the Tenant Volunteer Lawyer for the Day program in Baltimore City Rent Court. We've since expanded to Baltimore County, and our staff works alongside volunteer lawyers in both jurisdictions to provide day of court representation. The judiciary has embraced our program, recognizing its ability to increase the efficiency in rent court and save the state money while preventing homelessness. Last year, over 76% of our clients avoided eviction based on a valid defense raised by a staff or volunteer attorney. So these dismissals represent cases that really shouldn't have been filed. Last year, you passed House Bill 18, recognizing that having representation can prevent evictions that the law says shouldn't be happening to begin with. Utilizing volunteer lawyers alongside experienced staff attorneys can be an effective model, and our program was the first in the state to do so. Its success demonstrates that with appropriate organization, funding, staff, and volunteer attorneys can work together on behalf of tenants. Since we launched our program 4 years ago, we've trained over 180 volunteer attorneys representing 1,687 tenants. 42% of those cases were handled by volunteer lawyers who've provided over 1,200 hours of volunteer services. We find that volunteers appreciate that with our staff's attorneys as mentors, they have an opportunity to give back, and their work is a force multiplier for clients in need. Programs like ours would be a vital part of this access to counsel if funded. So we urge a favorable report on Senate Bill 662 to help fund access to counsel. Thank you.
Good afternoon. Once again, I'm Vicki Schultz. I'm chairing the Access to Counsel and Evictions Task Force, and I'm also here on behalf of the Maryland Access to Justice Commission. On behalf of both entities, we urge strong support for SB 662. As noted in the task force's first annual report that we issued in January, and I brought a copy, I hope you all have it and have had a chance to read it, it's really an urgent and critical need to get started with this program. Maryland Legal Services Corporation has estimated, as we said, about $12 million is required for the first phase of implementation in FY23. And that, as we did our research, we found that to ensure the success of this program, we recommend an annual appropriation in the state's operating budget as the primary source of funding for the special fund. Stable and consistent funding is crucial. And as you know, it's really important. One of the strategies, the key core strategy, is to provide legal representation for tenants. It's an effective eviction prevention strategy. Too few Marylanders have legal help when facing eviction, and there's a tremendous imbalance in the court system, as noted. So we also believe that there's a potential for greater outcomes, better outcomes for tenants and for all included. And in fact, what we've found is that when an access to counsel program is implemented, that it really results in greater fairness and also efficiencies in the court. It's better to negotiate when both sides are represented with counsel, as this body knows. The General Assembly expressed the intent that this program be fully implemented by October 2025. However, without this critical funding, that critical work cannot begin. So we urge a favorable report both from the task force and the Access to Justice Commission for this bill, and we thank you for your time.
Good afternoon, Mr. Chairman, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I bet most of you know what I'm going to say because you've heard me say it a couple times before this session. We have been consistent in our position on funding for the Access to Counsel program. We are supportive of the state budget being used to fund the program and bills like this being used to fund the program along with federal dollars. And so we think that this bill is a better way to fund the program, Senator Hellman is laughing at me, than unrecoverable court costs. With me, she's laughing with me. And so she's heard me say that a lot, so I appreciate you listening over and over and over again. And yeah, so I mean, look, do we have disagreements about how the budget was developed? Of course we do, but we are supportive of this bill, and we would urge a favorable report. Thank you.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you all very much. Thanks. All right, next is Katie Davis. Katie Davis already go? Yeah. All right. And Gregory Countess and Hannibal Kemmerer. And Nick Katz. And Heidi Dominguez.
Again, Mr. Chair and members of the committee, my name is Gregory Countess. I'm with Maryland Legal Aid. I'm not going to repeat the comments made by my colleagues. We just simply said we did written testimony. I see it says I have 2 seconds left. Is that true? That's the quickest 2 minutes I've ever been in. But one thing that, and I don't know if you need a reminder of why it was that you voted to support or set up the Access to Counsel program, but we would tell you, and of course you know, that it's really, really important. In fact, if you will bear with me, I'll just talk about 2 cases that currently have occurred. As you will know, the Court of Appeals suspended the hearing of rent court cases until early March. However, even with that suspension, our colleagues on the Eastern Shore report that cases are still being heard. And in fact, on Friday, this Friday, there are 100 cases that will be heard, and they'll be heard in a small courtroom in a small courthouse over on the Eastern Shore. We believe that's a danger. And other observations that we have made are that, for instance, we've had a client come in to see us where they got a judgment against them. And the judge in that particular case decided to sign a warrant for possession of the premises on the same day as rendering judgment in violation of the law. When in a stage, there should be a stay that should occur at least for 4 days to give the tenant or the losing party an opportunity to appeal. This was not done. And again, we're struggling with the number of cases that have been filed and having counsel in order to be able to represent these folks. And so in the meantime, we believe people with meritorious defenses are being evicted. And that's something that we would hope that with your approval, your support for Senate Bill 662, that will stop in the near future. And so thank you.
Thank you, Mr. Chairman. Hannibal Kemmer, representing the Office of the Attorney General. Thank you, Chair Smith, Vice Chair Waldstreicher, distinguished members of the committee. I am just going to say me too. The Attorney General, in his access to counsel his COVID-19 access to justice task force, recommended that we provide access to counsel in these situations. And in its wisdom, the General Assembly last year passed House Bill 18. We're thankful for that. We think that because the fund is now stood up, it needs to be funded, and so we urge a favorable report on this bill. Thank you.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. My name is Nick Katz. I'm the legal director with CASA, and CASA is pleased to provide strong support for SB 662. We are the largest membership-based immigrant rights services and advocacy organization in the region, with more than 120,000 Black and Latino immigrants, working families, members of CASA. We support the bill for two main reasons, really. Our members need access to justice. Every year, CASA conducts intakes with hundreds of Marylanders who face serious housing issues, including unjust eviction and other issues, but we don't have the resources to represent them in court. The pandemic has exposed a pre-existing and severe underlying power imbalance between renters and tenants. As Attorney General Frosch has eloquently pointed out, landlords across the state use housing courts as collection agencies. Sadly, we don't even see many of the cases that are filed because tenants feel helpless to assert their rights and simply pay up, even where there are fees not associated with their rent that they shouldn't have to pay. Second, we support this bill because access to counsel will help alleviate egregious housing violations occurring every day in Maryland. Without adequate legal counsel, tenants often assume there's nothing they can do about conditions that constitute serious violations of the law and may threaten their health or safety. Things like mold, rodents, lack of heat, other major violations. Secure in the knowledge that if their landlord retaliates against them, they will have counsel to represent them in court, tenants will be more likely to raise these issues. Last year, Maryland took a huge step forward in passing HB 18, the Tenant Access to Counsel Act. This landmark legislation helped level the playing field between landlords and tenants by making it more difficult for landlords to use the courts as collection agencies. This bill, SB 662, helps effectuate the vision of that bill. For those reasons outlined above, CASA strongly supports the bill and urges a favorable report. Thank you.
Excellent, thank you very much. Is Heidi Dominguez here?
Heidi Bautista?
Yeah, yes.
Buenas tardes, mi nombre es Heidi Bautista, soy originaria de Honduras. Llegué a Estados Unidos hace 2 años y medio. Soy residente de la ciudad de Baltimore. Tengo una niña de 5 años y una sobrina menor a mi cargo.
Hello, good afternoon. My name is Heidi Bautista. I am originally from Honduras. I came to the United States 2.5 years ago, and I am a resident of the city of Baltimore. I have a 5-year-old niece. My niece, and my sister all in my care.
Cuando llegó la pandemia, yo tenía 4 meses de haber llegado a este país. Ya estaba trabajando para pagar mi renta y mis gastos mes a mes, pero perdí mi trabajo de limpieza de oficinas. Hasta el día de hoy no he podido trabajar lo suficiente para pagar mi renta. He tenido que prestar dinero a familiares por el miedo de que nos desalojen de la vivienda y para que no nos recarguen los gastos a la renta.
When the pandemic happened, I had arrived just 4 months ago in this country, and I was already working to pay my rent and expenses month by month. But I lost my office cleaning job, and to this day, I haven't been able to work enough to pay my rent. I've had to borrow money from my relatives out of fear that they will evict us and to avoid paying additional late fees.
En casa todos tuvimos COVID-19 y tuvimos en cuarentena 15 días porque pagamos impuestos con el número de ITIN. No tuvimos el acceso al desempleo y a los cheques con estímulo. No teniendo cómo pagar la renta, llevo 3 meses de estar prestando dinero para pagar la renta. Me he enfrentado a una montaña rusa muy dolorosa y emocional de estar prestando dinero por el miedo de ser desalojada de la vivienda por parte del propietario y la preocupación constante de mí y de mi familia de terminar en la calle.
Everyone in my home became infected by COVID-19, and I have not been in good health since. We were in quarantine for 15 days, and because we filed taxes with an ITIN number, we did not have access to unemployment or stimulus checks. I didn't have a way to pay the rent, so I have been borrowing money for 3 months to pay the rent I owe. I have been facing a painful and emotional roller coaster looking for more loans due to the fear of being evicted by my landlord and the constant worry that my family and I will end up on the street.
La moratoria del desalojo ayudó a mi familia, pero sin una protección tengo miedo de ser desalojada y quedarnos en la calle. Recibimos una carta por parte del propietario de la vivienda que si no pagamos la renta a la fecha correspondiente, se nos harían recargos a la renta. La próxima notificación sería para desalojarnos. Sin un abogado sería imposible defender mi caso.
The eviction moratorium has helped, but without one, I'm scared to be evicted and left on the street. We received a letter from the landlord that will also pay additional fees for not paying on time. An eviction notice could be next, and there's no way that I can make my case without a lawyer.
Insto a la delegación a que apoye el proyecto a la ley para financiar el acceso a los abogados en caso de no poder pagar la renta y ayude a proteger a miles de residentes de Maryland que se encuentran en mi misma situación, defendiendo. Si pudiera tener acceso a un abogado gratuito, me sentiría segura de poder defender mis derechos como inquilino por nuestra casa.
I urge the delegation to support the bill to fund access to attorneys in cases of failure to pay rent and help protect the thousands of Marylanders like myself who find themselves in the same situation. If I could have access to a free attorney, I'd feel confident defending my rights as a tenant and be able to fight for our home.
Muchas gracias por darme la oportunidad y de escuchar mi testimonio.
Thank you very much for the opportunity to share my testimony.
Excellent. Thank you very much, Ms. Dominguez. And with that, that looks like that'll conclude the testimony for Senate Bill 662. We'll now switch to the committee for questions. Seeing none, thank you all very much. And with that, thank you, Senator Zucker. Thank you to the panelists. That'll conclude the hearing for Senate Bill 662. We'll now move on to Senator Heddleman with Senate Bill 563.
Thank you very much, Mr. Chairman. Can I bring up my panel? How are you? Yes, I know. How are you? Good afternoon, Mr. Chairman, members of the committee, Mr. Vice Chairman, members of the committee. Senate Bill, I'm Shelley Heddleman, for the record, Senator from District 11. Senate Bill 563 aims to correct a court decision that was made in December. I read about this in the newspaper, and I immediately called some folks, and I thought, we need to do something about this. It requires that local jurisdictions that require residential rental licenses before their landlord or agent may use the court system to file for an eviction for failure to pay rent, breach of lease, or tenant holding over, that the landlord must possess a valid license. There's a principle here and a value here. That is, one should not be able to use the legal system for enforcement if one is not first acting legally themselves. And if they are not in compliance with current law, they shouldn't then be able to go try and use that law to their advantage. Back in 2001, the court decided in McDaniel versus Baranowski, the Court of Appeals held that in a failure to pay rent case, the landlord must first be licensed in order to be able to evict a tenant. And then, unfortunately, as I said, this past December, in the Valicki case, Valicki versus Copycat, and you'll hear more about that case in a little bit, they strayed from their logic in McDaniel, and they did say that the landlord did not have to be licensed in order to pursue a tenant holding over case. Now, I just want to be clear. This doesn't change anything in counties that don't require a license already. And there are six of the larger counties, and I think over a dozen municipalities require licensure. The bill also makes an exception in a breach of lease case if a tenant is putting themselves or others in imminent danger, then the landlord can still go to court, so that we have that escape here. But local licensing laws are there for a reason. They're there to require that landlords adhere to health and safety codes, and they set a floor for standards. And this decision makes a mockery of those local licensing laws. And I just think that she got it right in her dissenting opinion. Judge Shirley Watts said, "This loophole presents an obvious risk of danger to tenants, as unlicensed landlords may now use tenant holding over actions to recover rent and possession of property and lease the property again with little incentive to eliminate hazards on the premises and obtain licenses." This bill closes that loophole. Now, I want to make it clear. Most landlords are good landlords, and they do what they're supposed to do in terms of safety and health compliance. This is really aimed at landlords that are trying to get around the system. You will note, and I have some data that supports this, that our tenant holding over cases are going up. And there's definitely reason to believe that some landlords are allowing leases to expire and then using the tenant holding over process to be able to evict tenants. So if we close this loophole, they won't be able to do that. I also want to make it clear that there's some opposition in the committee testimony that has to do with temporary licenses. I think those are issues that I think that can be worked out. And with no further ado, I will turn it over to my distinguished panel here and some folks who have real-life experience who can shed a little more light on the issue. Thanks so much.
Thank you, Mr. Chair. My name's Lee Ogburn. I'm an attorney at Maryland Legal Aid. The importance of this bill, in our judgment, is that it puts teeth into the efforts of local jurisdictions to improve housing conditions by requiring that lease premises be licensed. Licenses lead to inspections. Inspections lead to code compliance, and code compliance leads to improved housing conditions. This bill will enhance compliance with licensing requirements in the following way. Currently, unlicensed landlords are barred from using 8401 rent court, pay-to-pay rent cases. That's the rule in McDaniel versus Baranowski. The potential benefit of that rule should be that unlicensed landlords would be encouraged to get a license. But what we see on the ground, if you will, is that unlicensed landlords, rather than getting a license, seek to evict tenants by using a tenant holding over case brought under 8402. So they use, in short, they use 8402 as an end run around the requirement of being licensed to use 8401. This bill would put a stop to that practice. And that is a benefit not only to tenants, and particularly low-income tenants, but also to licensed landlords who compete with unlicensed landlords who do not incur the expense necessary to keep their premises up to code. And the bill would do that without imposing any additional burden on landlords. All a landlord needs to do to come within this bill is obtain the license that the landlord is already required to obtain by the jurisdiction in which the landlord does business. So for those reasons, we urge favorable report on this bill. Thank you.
Testing. Can you hear me? Okay. Good afternoon, Mr. Chair, honorable committee members. My name is Bill Henry. I am the comptroller for Baltimore City, but before I was elected to this office, I served 13 years on the Baltimore City Council. In my last term on the council, I introduced a bill to bring single-family and two-family houses under the requirements for licensure and inspection, closing a loophole, ironically enough, in what was then the least regulated part of the rental market in Baltimore City. We spent a lot of time on this bill, a lot of time putting it together, and then a lot of time getting it through the legislative process. Worked closely not only with the city's housing department, but also organized groups of landlords and tenant advocates, some of whom are here today to testify in favor of Senator Hedelman's bill. The important reason for doing this was because all landlords need to face basic structures when it comes to providing safety and maintenance for their properties. That's essential, and as government, it's an essential requirement that we should be enforcing, in which the license law in Baltimore City now mandates this. But it should also be essential that if landlords are going to try to use government's powers in order to take actions against their tenants, they should be following government's laws. I'll admit I was a little tempted, listening to the sponsor describe this, to just stand up and say, me too, because she made the great point that this is basic common sense. Landlords should have to follow the law if they're going to use the law to get rid of their tenants. Thank you very much.
Thank you, Chair Smith, members of the committee. I'm Indigo Vulicki. I live at the Copycat Building in Baltimore City, and I'm here because I know it is impossible to keep tenants safe while unlicensed landlords can use our courts for eviction. I constantly breathe lead and asbestos when I'm in my apartment. As of November, I have no working refrigerator. Hundreds of roaches swarm out of a visibly rotting wall in my kitchen and into my home. I am regularly forced to sleep in temperatures in the low 40s in the winter. The last time this past week. Often, I don't have enough water pressure to properly wash my hair. You will deal with a lot if the threatened alternative is homelessness. I'm the defendant in Velicky v. Copycat. In its majority decision, the Court of Appeals said they felt my landlord, Charles Langford, should be allowed to evict me despite his being unlicensed because he claimed he didn't want rent money, he just wanted me out of the apartment. I encourage you to read the dissenting opinions, which enthusiastically disagree. The ruling doesn't show the big picture. Landlords lose their license because their buildings are unsafe. Unlicensed landlords can't legally collect rent. So theoretically, landlords should be motivated to keep buildings safe if they want to rent them. Unfortunately, some landlords have found a way around this, tenant holding over, an eviction method that does not require a rental license. Using tenant holding over, landlords can threaten a tenant with homelessness regardless of having a license or a safe building. This is what my landlord, Charles Langford, has been using for years to extort illegal rent payments from tenants like me. During the pandemic, my landlord explicitly said he would use tenant holding over in retaliation if we couldn't pay rent. I will read part of an email he sent to his tenants, including me, on June 15th, 2020. He says, "To be clear, only rent court is part of the eviction moratorium. We use tenant holding over court. We will be filing for your eviction, and your remaining debt will be turned over to a national credit agency, which will negatively impact your credit for the next 7 years. Thank you for your time today. Please read my full written testimony."
All right, thank you very much. Questions from committee? I saw Senator Castley and then Senator West.
Thank you. I guess it's probably maybe Mr. Ogburn and Mr. Henry. Look, I don't think there's any opposition to this bill in this committee, and the only concern is the language that says that you can't accept a temporary or provisional license. So if a given county says, when you apply for your license, it takes 6 months to get it, but we'll issue a temporary or provisional license for those 6 months, and then this would say, no, the court can't accept that. Why should we not allow for temporary or provisional licenses?
Senator, I'm not qualified to answer that question. To be completely blunt with you, I understand that there's openness to amendment to the bill to address the issue you're concerned, but I'm not the person to say
I know in
what that
the
amendment would
eviction
look like.
cases, it's actually on the form that says you've got to give your license number and say what your license is, and that's how they verify it. And obviously, that's not for the holding over. So I mean, yes, and run, but you know, I don't have a problem with the bill, but it just seems to me that if a given county says they're going to issue temporary or provisional, we ought to accept those. And I mean, this is enforcement of the local law. So that's my only. Thank you very much. Appreciate it.
So my understanding, and I think we'll have some panelists who can address the issue, but my understanding is one county, Prince George's County, issues temporary ones. And so I think another panelist will be able to address specifically the issue just in Prince George's.
Okay.
Thanks.
Thank you, Mr. Chair. So Mr. Ogburn is an old friend, and now I get to question him in public. And so here's my concern. In corporate law, a corporation can't go into court and sue if the corporation is not in good standing. But the corporation doesn't have to, in every case that the corporation files in court, prove that the corporation's in good standing. It's up to the defendant to suggest to the judge that the corporation is not in good standing and raise the issue that way. But in this bill, it says that on the filing of a written complaint to repossess, the landlord shall submit to the clerk of the court records demonstrating the property is licensed. And then it goes on, at trial, the landlord must prove by preponderance of the evidence that the property listed is licensed. And so my question is, why do we want to drag out trials by requiring this sort of proof in every single trial in court? Wouldn't it be better, now that the tenants are going to be represented by counsel, paid for pro bono by the public, the tenants' counsel can certainly raise this issue if it is the case. Why don't we let this situation be handled in the same way as the corporate situation, namely the defendant should raise the issue in court, rather than requiring the plaintiff in every single case to prove that he's in good standing?
I believe that the answer to that, Senator West, is that as a practical matter, currently, tenants are not represented in court. A small percentage are represented. And unrepresented defendants do not have the sophistication to address the issues that
I
you've
completely agree with you, but
just
but
raised.
we're in the process of making sure that we have legal counsel for the tenants provided for.
We are, and of course, you're going to know much more about this than I, but I believe the compliance date with that is 2025. And it is in
No,
any case.
I think we're going to do that sooner than that.
I hope I'm wrong about that, but I believe I've heard that so we're years away from that circumstance, and even when counsel is available to tenants because counsel is paid for, not every tenant is going to walk in a courtroom with a lawyer next to him or her. And so I think the issue you've raised is one that's intended to address the on-the-ground circumstance of numerous unrepresented tenants walking into court and not realizing the issue that is potentially there. And I expect that the rationale for requiring that there be proof at trial in addition to the complaint is so a court can make a decision about someone qualified to determine whether or not a landlord is licensed, can make the decision that the landlord is entitled to be there.
All right, let me pursue that a little bit. Another provision in the same section says, to satisfy the requirements of this subsection, a landlord may provide electronic proof of licensure. I'm not sure how that works, and how would that be admissible in a court? An electronic proof of licensure, what is that like? You show your cell phone to the judge?
Well, that may be the answer.
Well, that doesn't sound like that's admissible evidence.
I think the purpose of that provision, and I didn't draft it, but I believe the purpose of that provision is to facilitate the process and reduce the burden on the landlord. Landlords have said, you know, finding the paper is difficult, or generating the paper is difficult, or arriving with the paper is difficult. Right. And that's an effort to address that concern, to keep the playing field level.
Okay, well, that makes a lot of sense if we can figure out how to do it and have it successfully introduced into evidence in the trial. Last question. There's this section early in the bill, which nobody's commented on, that says if a court determines that a landlord asserted a breach of lease in bad faith and without substantial justification, the court may enter judgment for the tenant and award costs and expenses, including attorney's fees. Where did that come from? It sounds like it's extraneous to the issue we're talking about here.
I believe it bears on the issue in this way. The bill excludes from its scope claims brought under, I believe it's Section B of 8402.1, which provides for 14 days' notice in the event of a claimed breach of lease that is a danger, involves either a danger to the tenant or a danger to other tenants. Mm-hmm. And recognizing that the time matters in that circumstance, the bill doesn't apply to that circumstance. And I believe the provision that you have raised is an effort to avoid a unprecedented number of 8402.1B claims involving the 14-day notice, and that's not an unfounded concern, I believe. The legislative history of 8402.1 is that it was enacted to prevent landlords from incorrectly bringing 8402 claims when they actually had a breach of lease other than tenant holding over. So 402.1 was to address those other claims, 402 being misused for the purpose, and this is an effort to avoid misuse of a section of 402.1.
Great. I think I followed your argument, and thank you very much for your answer.
Thanks, Mr. Chair. And as somebody who's dealt with real estate in Prince George's County, I've always had to show my rental license when I went to court. Now, there were times where I had to show a temp license, and that was acceptable, but we know the issue is that with the temp license, it can take up to 3 months before an inspector actually inspects it. So this is more than just showing a piece of paper. This is about ensuring the adequacy from a safety perspective for tenants, which is why I love the bill. My question, though, is nuanced. I know somebody's going to talk about the temporary license thing, but with Prince George's, as long as you are not in a municipality, the bill applies. And the exact reading of this, all single-family, multifamily rental licenses are administered except the following cities and towns which are not licensed in our jurisdiction: Bowie, city I represent; you know, Riverdale Park, Sea Pleasant, New Carrollton, and a variety of others. It's about, it looks like about 16 different municipalities. How is that handled under this bill? Are they just absolutely excluded and don't have to conform?
Yeah, I think that's really a question more for the sponsor than for the panel.
I will follow up with you separately.
Thank you, Senator. Thank you, Senator Edelman. Thank you.
Seeing no further questions, thank you all very much. Thanks. Let's hear from DePaul Nibber, Katie Davis, Zafar Shah, and we'll go with Mr. Countess. Maybe still.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is DePaul Nibber, representing the Maryland Association of Counties in support of SB 563. Across Maryland, 6 counties have developed rental licensing schemes. As mentioned in our written testimony, these laws were enacted to bolster zoning and code compliance for the welfare of Marylanders. They also serve to give county and state officials a better idea of available housing stock and where potential deficits might be. To allow an operator of rental properties to proceed with an eviction proceeding without compliance with local laws implicitly suggests these laws have no force. Unlicensed operators will continue with noncompliance if their ability to collect rent and evict tenants remains intact. Absent this bill, local licensing schemes will be completely undermined, and for this reason, MACO urges a favorable report on SB 563. Thank you.
Good afternoon. Thank you, Chair and committee members. Again, I'm Katie Davis with the Pro Bono Resource Center of Maryland. Since 2017, we're providing day of court representation for tenants in rent court, and we currently represent tenants in both Baltimore City and Baltimore County. And as you know, Baltimore City, where we operate 4 clinics each week, is one of these jurisdictions that has elected to require rental properties to be licensed. This licensure protects tenants by requiring routine inspection for unsafe conditions, and a landlord may not collect rent or use some rejection procedures without a valid license. In recognition of this provision, we routinely check for license when we meet clients in court. In the 2 years prior to COVID-19, almost 1/2 of PBRC's failure to pay rent cases were dismissed for lack of valid licensure or registration, and that represents a significant portion of cases in which the landlord chose to take up valuable court time rather than follow the law by getting a license. We support this bill because it will increase court efficiency. If a filing lacks proof of licensure, it can be rejected at the time of filing. This bill will protect tenants by encouraging landlords to maintain safe homes for their tenants, and will help those landlords who do so by ensuring that those who don't cannot waste valuable court time. In the long run, this will preserve judicial resources for those who need them. We support Senate Bill 563 because it will prohibit landlords from circumventing the licensing requirement by entering short-term licenses only and then filing a tenant holding over action rather than failure to pay rent. We recently had a client who'd been living in an unlicensed home without consistent electricity or plumbing for over a year. When he lost his job due to COVID, his application for rental assistance was denied because his residence was not licensed. Yet his landlord was able to use the courts to secure an eviction by filing a tenant holding over rather than failure to pay rent action. It's important to note that these tenant holding over actions are very difficult to defend. For these reasons, we request a favorable report on Senate Bill 563. Thank you for your time.
Okay. Good afternoon. Chair Smith, Vice Chair Wallstreicher, members of the committee. My name is Zafar Shah. I work at the Human Right to Housing Project at the Public Justice Center. As an attorney who does day-to-day work in the rent court in the city, in the 6 months before the first pandemic shut down in March 2020, 56% of public justice centers' trial representation cases involved a landlord who was unlicensed. There are other studies that have occurred, PJC's in 2015, which found that 70% of landlords had omitted or reported false licensing information on the complaint, but still won a judgment. Legal Aid, in a 2016 report, discovered 21,000 judgments, default judgments entered despite flaws with the stated rental license number. So this continues to be a problem in our district courts, where, as you know, there are well over 600,000 failure to pay rent cases filed each year. To Senator West's point, only 3% of those cases involve a defendant who shows up. So their ability to contest this issue is not at the scale that the court actually requires. We need this sort of prophylactic measure to ensure that we not only have a clean hands doctrine, but a court with integrity. And I bring up that point because the Baltimore sheriff, deputy sheriff, asked me recently. He said, "Why are my deputies aiding and abetting a crime, which is to carry out an eviction for an unlicensed landlord?" And the answer to that question is because we don't have black letter law stating the burden of proof on a landlord to show valid rental licensing at the time of trial, whether it's failure to pay rent or tenant holding over or breach of lease. That's what our state needs and has needed for a very long time, well past the McDaniel versus Bernowski decision. So Public Justice Center seeks your favorable report on this bill.
Senator Hettleman, do you have a question, or?
No, my light was on, but I actually have an answer to the Prince George's question, if that's okay.
Sure.
So my understanding is that they are the only jurisdiction that uses provisional licenses for single-family rentals and short-term rentals, and they're good for just 90 days. And the Prince George's County Permitting Department staff, I guess, made it clear to a colleague from Prince George's that they don't rush the process of review and the unit inspection during that 90-day period in support of a landlord who wants to evict a tenant prior to the issuance of the regular license. The Prince George's Permitting Agency adopted the provisional licenses to deal with a large monthly volume of single-family rental applications and staffing challenges. So that, I hope that answers Senator Watson's question.
Thank you, Mr. Chair. I missed the last gentleman who testified. I missed his name, but I've got a question for you. So you obviously have some experience in these rent courts. So my understanding is that the courts typically schedule a whole bunch of cases filed by the same landlord for the same morning. So the landlord will send their attorney there, and there'll be case one, first case and second case and third case, et cetera, in a series until all the cases filed by that landlord have been disposed of. So what I'm concerned about is how much court time is going to be taken up by proving in every single case that the landlord is licensed. And I'm intrigued by this idea of electronic proof. Have you any idea, how would that work, and how would it work in a way that would not cause the court to be bogged down with this kind of proof every single time a case comes up? As you said, in most cases, the tenant doesn't even show up. So are we going to require in every case the landlord to go through the rigmarole of proving that the landlord is licensed? Or isn't there a faster way, maybe through this electronic proof of licensure, to deal with this issue?
Well, I think that, in the future, and this has been, sort of posited for several years now, which is that MDEC will allow landlords to provide the electronic copy of their rental license at the time that they file their case. And so that might, if that does happen, create some efficiencies on day of trial where documents are already on record and need only be spot checked or reviewed by the judge as the trial begins.
Yeah, that would make some sense, and the judge would just go through the papers and find that that paper is there. But this bill goes on further and says, at trial, the landlord must prove by a preponderance of the evidence that the property listed is licensed. So it would suggest that you wouldn't just file a piece of paper when you file your case, you'd have to prove it when you get to the trial.
And that's exactly right. And I think that sort of, again, in the practicalities of the way the district court operates, what you would have is not dissimilar to tenant holding over cases where the court looks at the 60-day notice that was attached to the complaint or looks at the 30-day breach of lease notice. There's simply probably a review that the document's there, asking for that attorney or the plaintiff to attest that it is true and accurate. And, you know, it takes 10 seconds. I understand that it could appear that this will take a lot of work or a lot of energy or spinning of wheels. I think that these cases do work lightning fast when there is no defendant party present. We haven't heard really opposition the past few years with bills like this that you know, there would be such a slowdown because of this issue. It's really been about just whether it has to be a paper document or an electronic document. To your concern, Senator West, about authentication, I do see this day in, day out. I'm sure Ms. Davis does, whether in city or the county, which is that, you know, a PDF on a phone, on a tablet, can be passed up by the bailiff to the judge, and it is not a matter of authentication problems because the rules of evidence don't technically apply in a failure to pay rent case.
Okay. I just scribbled as you were talking.
Yes.
If instead of the bill reading must prove by a preponderance of the evidence, it were to read established to the satisfaction of the court, would you have a problem with that?
On the spot, I would suggest I don't have a problem with that.
Okay.
As that does line up with a lot of language in the real property code for these summary cases.
Okay, great. Thank you.
Mr. Shaw, you mentioned that you said 56% of the landlords that brought a case were not licensed. Was that right?
So the specifics were that in the 6 months prior to this kind of erratic scheduling of cases that happened during the pandemic, we looked at our trial representation cases. So the cases where we were defending someone, trying to state maybe a rent escrow defense or some other defense. Just in those, 56% involved a landlord, a plaintiff, who shouldn't have even had a case in front of the court because they were unlicensed.
It's incredible. So Mr. Ogburn obviously, you know, laid out, I think, quite well the benefits of licensure because of all the other additional benefits for housing and for the tenant. But I'm trying to figure out how is it that so many folks are able to operate without licenses. And we looked up, for Baltimore City, it's a misdemeanor and a $500 fine a day. Just how is that even happening to this extent?
Well, that penalty provision is simply not enforced in any way that we think is meaningful. The ability of a tenant to take matters into their own hands has been stifled just by there being new precedent that a rental license statute like Baltimore City has doesn't have a private right of action. And so tenants who withhold their rent are probably doing the best they can, but tenants who, unaware of the unlicensed status of the landlord or aware of it too late and have paid and provided that money to the landlord, they are having, you know, they face this decision which says they can't sue to get that money back. And so as long as there is both the leverage to demand rent as well as the leverage to kick someone out or collect rent through the court, you will have unlicensed actors. And again, it's a minority. But unfortunately, this is a minority of actors who understands the leverage they have. They will use it.
It's incredible. All right. Thank you very much. Okay. Thank you all. Seeing no further questions for the panel, thank you all very much. We'll now go on to, is Mr. Countess still here? And Mr. Wiggins? Oh, you're good? Okay, great. And, no, that Anna already went. And Ms. Howard, yep. And then we'll go to Mr. Costelli.
Good afternoon. Kathy Howard once again, at this time representing Regional Management, Inc. We are a member of the Maryland Multi-Housing Association. And I think I want to start out my testimony in saying the sponsor indicated that this was a bill that's about enforcement of the rules regarding licensing. And that's great when you're talking about the Baranowski case and rent collection. But what we're really talking about in 8402.1, which is the tenant holdover statute, and 8402.2, which is the breach of lease section, is possession of the property when there is an end of the lease, when the agreement is over, either because of a breach of lease that needs to be proven or because of the term of the lease is over. And the case that, in the copycat case, barring some of the antics, I will call them, of the landlord, is all about whether or not a license is necessary in order to regain possession of your property. And the court held that that was not a prerequisite that had to be delivered. The court is there to give possession or determine whether or not possession should be given back to the landlord. That's not something that a license will or will not give to you. Enforcement of code violations and things along those lines. I'll give you an example. In a breach of lease case, not an emergency breach of lease case, but a regular breach of lease case where a tenant has done something that creates a code violation that ultimately makes the landlord lose his license, whether it's temporary or not, is something that the landlord needs to be able to take care of by giving proper notice and getting tenant out under the breach of lease statute. This bill, if it passes in its current form, would tie the hands of the landlord completely. He's got a code violation that the tenant is responsible for. He cannot get into court because on a breach of lease case because he doesn't have a license, because the tenant has done something to the property that has messed up the license. And that is the Hobson's choice and the problem that this bill has not really addressed. And we really do need to keep that in mind. And I appreciate, though, that the sponsor is looking at the temporary, taking out the temporary license provision, because that is a problem. In Baltimore City right now, although licensing has been in effect since 2018, unfortunately, they are going into a new computer system right now, and all of those licenses are in extension status. I don't know whether that's temporary. I don't know whether that's an extension, but that's what's going on in Baltimore City and happens all over the place. But thank you very much for your time, and we are favorable with amendments.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. You have our written testimony, which is favorable with amendments. We have amendments delineated within that testimony. I do want to quickly cover a couple of them. First, we would like to see reciprocal language regarding the costs and awards for breach of lease cases. Second, regarding the provisional and temporary license, I'm glad to hear that the sponsor is willing to have that discussion. I am humbly a very young attorney, but I don't believe that temporary or provisional license is defined within the bill or the statute, and so I'm unsure of how that would be defined moving forward. I'm also concerned that, right now there are no temporary or provisional licenses in certain jurisdictions, but that doesn't mean there's not going to be some next year, in a couple years. There's no requirement in the bill that a county would have to refrain from offering those. Finally, I would be interested to see the data behind the 56% number that was referenced by one of the proponents of the bill. What we've found is that some of these organizations represent a very small number of cases, and so while 6% may sound large, it may in fact be a small number in the aggregate. And so with that, I would simply ask you to refer to our written testimony and be happy to take any questions.
All right, seeing no questions, we'll switch them to the opposition panel. Mr. Castelli.
Thank you, Mr. Chair, members of the committee. Bill Castelli with the Maryland Realtors. And my testimony really, even though we are here in opposition, is really focused on the temporary license. You've heard some of the discussion of it. You even have instances where someone who's had a license for a long time renews the license, is given kind of a temporary provisional status until that inspection is done. We just want to make sure they don't get caught up in that. So
we'd appreciate, further discussion about that and trying to figure out that.
Senator Watson.
Thank you, Mr. Chair. Mr. Costelli, just a quick question. So I've had several licenses. They're good for 2 years. They elapse. It's not something you think about if you have a tenant who's good to go and properly doing their thing. But when those things come up, in order for you to act as a landlord, then you have to go get a temp license and try to regain, your property. So my question is, when there is an issue in the home, say it fails inspection, the license is not revoked. There is a time to repair, is it not?
Well, I'm not exactly sure under Prince George's County law what their step is. I mean, certainly in the state law, there's a period that you have to repair, the landlord would. And how that intertwines with, the local jurisdiction and their rent licensing requirement, I would have to get back to you on.
Okay, thank you. And I did go back, Senator Heddleman, all of those other 7 municipalities, they all have their own housing licensing situation. Thank you.
All right, thank you very much. We all learned a lot. All right. And with that, I think we're good to go there. That concludes the hearing and the testimony for Senate Bill 563. We'll now move on to Senator Lee with Senate Bill 564.
Yeah, thank you, Mr. Chairman. Can I have my panelists come up, please? Come up, panelists. Okay. SB 564 aims to connect tenants with counsel at the time of the hearing if they fail to connect before that time. It just allows the time to speak to an attorney, builds trust in the system of justice itself. The brief pause to connect with counsel will significantly improve the effectiveness of services as well as the efficiency of the model itself. As many people sometimes don't get that attorney in time, or they're left without any kind of resources or recourse. Foreclosures, evictions, and defaults are lagging indicators of the economic chaos brought on by COVID, of course. And there are over 100,000 Maryland households that are behind on rent, and the federal funds are running out. So this is a very terrible crisis. This is a minor pause to provide services to those who need it the most, and for a fundamental need, of course, housing, the fundamental right to have housing. Marylanders deserve security in their homes to foster stable atmospheres, of course, to raise their families and their children. And we want to take some kind of reasonable actions to avoid separating people and their families from their homes. For Marylanders to fully avail themselves of federal rental assistance, they need time to gather their documents, process the applications. The access to these resources should be allowed when we are at the critical juncture when a person perhaps is made homeless. For these reasons, we ask a favorable report on SB 564. And the panelists who deal with this situation on a day-to-day basis will provide you with some of probably your answers to some of the questions. Okay, go ahead, panelists.
Thank you, Chair, Vice Chair, and committee members. My name is Meredith Gerard. I'm the Executive Director of Midshore Pro Bono. We're based in Easton, Maryland. We provide free and low-cost legal assistance to folks in our community who otherwise couldn't afford it. We have been providing in-court assistance for tenants throughout the pandemic. And I just want to share an example for you of how this could really help folks who are struggling with these issues. Just recently, we had a volunteer attorney who was working with a tenant who had a failure to pay rent case. It was called by the judge. They'd been out in the hall meeting and discussing, and the docket was called, and so the tenant had to go in before the attorney really had a chance to figure out what was going on and, develop defenses. So the attorney went with the tenant up before the judge and requested a continuance. Now, this is a little bit unusual for failure to pay rent cases. Oftentimes, the volunteer attorneys are really there to just present the defense. But in this situation, this tenant had not had heat in their apartment for nearly a year. So this entire winter, throughout December, January, February, through these freezing temperatures. So there's always more to the story. By allowing the continuance, this meant that the tenant was able to get an inspector out to the apartment. The inspector came back with a huge list of issues, and ultimately, 2 weeks later, when the case was reheard, then it was dismissed. So without some procedural pieces in place to ensure that tenants have the ability to both meet with a volunteer attorney on site or to be able to request a continuance, to be able to obtain counsel, gather evidence, and present their defense. This particular situation was very fortunate, but we need that to be happening in every courthouse. Thank you so much for considering this bill, and I really encourage you to support out of committee. Thank you.
Good afternoon, and thank you. Again, I'm Katie Davis with the Pro Bono Resource Center's Courtroom Advocacy Project. As you know by now, we partner with the Administrative Office of the Courts and other funders to provide day of court services in Baltimore City and Baltimore County, and we are in favor of Senate Bill 564. I want to take a minute just to paint for you a picture of what rent court looks like in our experience for our clinics. Most tenants arrive just as court is starting. They're often confused, they're nervous, they're stressed out. For many tenants, it's their first time in court, and they really don't know what to expect. We set up in the hallway. We have volunteer and staff attorneys set up available for counseling, but often tenants rush right by us because they're anxious to get into the court before the hearing starts. In many courts, also have staff from other rental assistance and other organizations available, but the tenants, again, head right into the courtroom. It's not uncommon for tenants to have their case called without having time to speak with us or our staff attorneys or any of the other service providers, and many of these tenants leave court that day with a judgment against them despite the presence of help right outside of the hallway. This bill would change the scenario by simply allowing these tenants a short recess to come into the hallway and speak with us or other providers, and it could then change the outcome of the cases as you just heard. Our attorneys, like I'm sure other attorneys, work very quickly, and sometimes they just need a few minutes. And you may be asking why these tenants simply can't call ahead and avail themselves of our assistance prior to the court. The short answer to that question is just lack of capacity. Even with the help of volunteer attorneys, legal services providers such as PBRC simply don't have the staff to represent tenants on a call-ahead basis. That's why we set up our clinics the way we do and catch them on the way into court. In addition, I think that's really the wrong question to ask. The better question is whether we should be evicting tenants who have a valid defense to the eviction or could avail themselves of rental assistance funds to pay their debt. So for those reasons, we ask that you have a favorable report on this bill, and thank you for your time.
Good evening, Vice Chairman and members of the committee. Thank you for listening to our testimony today. My name is Michelle Lim, and I'm currently a law student at the University of Maryland Francis King Carey School of Law. I participate in the mediation clinic. Our clinic has provided mediation services in the district court for over 15 years. I'm here today on behalf of the clinic to urge a favorable report of this bill. This bill is beneficial to the state of Maryland, the judiciary, landlords, and tenants because it allows for parties in certain landlord-tenant proceedings to take advantage of eviction prevention resources with minimal financial impact. The bill, in short, provides the time needed to access these resources. For many reasons, landlords and tenants are unable to take advantage of eviction prevention resources prior to the court hearing. As you heard earlier, landlords and tenants are often unable to connect until the day of trial. This bill gives parties the ability to request and the court the authority to grant appropriate time to allow parties in rent court proceedings to settle their disputes outside of the courtroom in a manner that preserves the dignity of tenants and has the potential to save both time and money for landlords. The use of alternative dispute resolution, or ADR, especially mediation, is a proven eviction prevention measure. In fact, the District Court ADR office supports day of trial mediation for landlord-tenant matters in courts throughout the state. The District Court conducted a pilot program in 2016 where 81% of the cases that went to mediation reached an agreement. A similar program in St. Louis, where an average of 43 eviction cases are heard per day, has been proven successful. Cases referred to mediation day of trial see a 71% settlement rate. This bill makes use of the ADR office and its partners to serve the interests of the judiciary. And this bill does not change the rights of landlords or tenants. It affords them the chance to exercise their rights by way of the district court's already existing ADR infrastructure. We respectfully urge a favorable report for this bill. Thank you.
Thank you, Ms. Lim. Questions for this panel? Question by the sponsor.
When you have an eviction service provider available for the tenant, usually a tenant is probably unrepresented and doesn't know their rights. So you have to be on the premises on the day of trial, is that correct?
That's correct.
Okay, and also with respect to the ADR, has that proven very good outcomes in Maryland with that particular program? I guess, Michelle, you can answer that question.
Yes, it has been proven very successful. And the ADR infrastructure is already at the district courts, and we're just waiting for referrals. So we are there day of trial.
So it has a successful track record of producing good outcomes where
Yes.
where the tenant and the landlord can come together and resolve the issue of the payment of the rent.
Yes, it does.
Thank you.
All right, excellent. See no further questions from the committee. Thank you all very much. All right, next we'll hear from DePaul Nibber, Zafar Shah. It's Gregory Countess. And that's it.
Okay. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is DePaul Dibber, representing the Maryland Association of Counties in support of SB 564. As we mentioned in previous testimony, our counties have distributed over almost $250 million in total financial assistance to families across the state. This bill would address a number of issues facing our Housing and Human Services officials with respect to the ERAP program. One theme that has persistently been raised by these officials has been that rental assistance eligible members of the public are simply not aware of the ERAP program. More time is needed to reach these folks. And so our county officials have really worked tirelessly to identify trusted messengers and develop informational materials for landlords and tenants alike. Similarly, many jurisdictions have worked rapidly to increase capacity to ensure application processing, but they essentially have had to start from scratch. But we will note that the program began in March of last year and has steadily increased in capacity in each month, closing out 2021. I'd also note that there have been outside influences contributing to delays in processing applications as federal requirements have shifted with respect to proof of hardship and reporting. For example, proof of income requirements and lease agreements have become significantly more relaxed, somewhat easing backlogs. In addition to hurdles imposed by the federal government, county officials have experienced pushback from landlords willing to accept rental assistance payments. This bill will prevent our shared constituents from succumbing to housing insecurity, potentially resulting in substantial damage to our social safety net. For these reasons, we urge a favorable report for SB 564. Thank you.
Good evening again. Chair Smith, Vice Chair Wallstreicher, members of the committee. Again, my name is Zafar Shah, housing attorney at the Public Justice Center. We provide legal services on day of trial at the Baltimore City District Court. Really, we've been doing that since 2014. We pioneered that model with the support of Judge Mark Skirty because we recognize that the most effective way to provide legal services to tenants when they realize they most need that help is at court. And the most, the highest impact conversation you can have with a tenant about their legal rights is when they sense that they're in jeopardy. The work we've done in the hallway at the district court has impacted tenants and landlords to their benefit as we work to resolve situations that those litigants thought could not be resolved except in front of the judge. But the problem with all the programs you've heard from today is that we have inconsistent access to litigants at court. And that inconsistency will not be resolved by a 10-day pre-filing notice from House Bill 18 or through the Access to Counsel program, which did not provide the mechanism to seek counsel if you show up without counsel on day of trial. In my written testimony, I've provided some modest data from a survey we conducted of legal service providers in Maryland. 30% of attorneys reported that they could rely on local courts in all or most cases to continue eviction proceedings so that the tenant could seek representation from their pro bono program. That's just 30%. And so what that tells you is that we have a long way to go. We can work with the good judges who make the great decisions here to allow us that access, but there are some who will not. If we have any aspirations to use federal funding for eviction diversion initiatives, which are available right now, we will have to tweak our eviction procedures. So Public Justice Center urges your favorable report on SB 564.
Mr. Chair, members of the committee, my name is Gregory Countess again with Maryland Legal Aid. As you know, Maryland Legal Aid has offices all around the state, 12 offices as a matter of fact, and we represent clients in a number of subject areas. And it's for that reason that though we may have limited same-day in-court sorts of representation, because of the way that we receive our money and because it covers different subject areas, we have to check for conflicts. And to do that, we do that in our office, so that it's very difficult to do that on the same day. And so oftentimes we have clients who come into our office who are requesting assistance, and and particularly we're not talking about failure to pay rent actions, we're talking about breach of lease and tenant holding over actions. And in those cases, sometimes because our clients are poor, because oftentimes they're in low-wage jobs, because they don't have good personnel packages to have great vacations and whatnot, or the ability to be able to do that, oftentimes they have to structure or ask for a vacation day 2 weeks before it occurs. So the result is that folks often come in to see us oftentimes at the last minute, and we have to ask folks to request the postponement so that we can be available, so that we can go through all the processes we have to go through. And what our observation is as backs up the information that Mr. Shaw just presented to you, in most cases, folks aren't getting postponements. And this bill just makes good sense. I think that with the previous bills that you considered today, in order to make access to counsel effective, this bill should pass, and we would urge a favorable report.
All right, seeing no further questions from the committee, thank you very much. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we'll hear from Mr. Wiggins, Mr. Castelli, and Ms. Howard.
Mr. Castelli was called to a meeting.
Good evening. Again, Kathy Howard for Regional Management. We're a member of the Maryland Multi-Housing Association. I think I want to clarify one thing that seems to have been overlooked in this situation. This bill is drawn to the wrongful detainer statute. And while I am, very happy and very supportive of all of the good work that is going on with the right to the access to counsel in failure to pay rent proceedings and things like this, we're talking about a wrongful detainer action. A wrongful detainer action is completely different from a failure to pay rent case. This is where a person is a squatter, has no right to possession, under a lease, an oral lease, or any other right to possession, and is in someone else's home, whether it be a rental home or an abandoned property, or not abandoned property, but a vacant property of that person. And a wrongful detainer action is the only way that you can, as the owner of that property, get that, and I'm going to use the word squatter because that's what is used in the law, to get out of that property. In that case, there may be some role that council could play, but I think that what we're really talking about here is something that should apply, is really a possessory action where someone is in a property without any right. And I think that is, if we're going to talk about the access to counsel in other kinds of cases, which is what everybody tonight has already done, that's great. But in wrongful detainer cases, I don't think that it is applicable, and I would ask for an unfavorable report on this bill.
Good evening, Mr. Chairman, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. We are unfavorable, and let's talk about why. So we've talked in this committee last week about the delay between a filing and a hearing. We've heard from some proponents that there's been some discrepancy. There hasn't been. We've been very consistent that the court process is historically delayed. I brought some examples. Let's go through them. Filing in July for failure to pay rent in Baltimore City, July 2021, given a hearing November 3rd, 2022, 15 and a half months between a filing and a hearing. I was asked last week if there's cases in Prince George's County where a year-long lease would run out before a hearing is scheduled if the person began or stopped paying rent day one of the lease. I brought an example of that from Prince George's County. Montgomery County, filing from June 2021. It was initially scheduled for March 2nd, which is almost 9 months after the filing, but it had to be rescheduled because of the court closure. It has not yet been rescheduled. I've got examples from Anne Arundel County of multi-month delays. Some proponents have held that out as the expeditious jurisdiction. There's multi-month delays there. I actually have cases, these are my two favorite, that were filed in August of 2021 and July of 2021 in Baltimore City, and they are scheduled for 2026. So you have access to counsel be fully implemented before these cases get heard. And so, that's the kind of delays we're talking about. I've got copies, I've got other cases. I've got a letter from ERIT Filings, which manages about 20% of the state's filings annually. They talk about the significant delays. They note that they have a lot of cases from February 2021 that have still not been scheduled for a hearing in Prince George's County. So we know that's going to be a significant delay. I'd also point out that this bill, we addressed this last year, I thought. There's now a 10-day notice where on the back of it, it's got phone numbers and email addresses for every one of these legal service entities. So a tenant gets that before a failure to pay rent filing. We also extended out the THO notice piece as well. So, with the exceptional delays, and I'll wrap up here, Mr. Chair, with the exceptional delays in the court system, with the additional time that we just gave last year, we think that that is a sufficient time for somebody to get connected with legal services. Thank you.
Thank you, Mr. Chair. Is it appropriate for me to direct a question to the sponsor of the bill? I wonder whether it was the sponsor's intent to have this bill written so it only applies to wrongful detainer actions, and so that the effect of the bill would be to give people, squatters in people's houses, access to legal counsel and more time?
The intent to apply to really cases like that where it's clearly like the tenant just won't leave. This is more or less to avoid eviction of cases dealing with like everyday people who are don't have representation, are not aware of their rights, and they're coming to trial on the day and they find out that they're going to be evicted, and they just need a little bit of time to seek legal counsel and to seek some of these eviction service providers that could help them obtain the documents they need to show or prove a claim of defense, or to demonstrate that, you know, it's the best interest, to at least give them a little bit of time to be able to get their things together and be able to perhaps resolve this with the landlord.
As I read the bill, that was my impression, but based on Ms. Howard's testimony, it sounds as if someone drafted this to the wrong part of the code.
Will the panelists address that issue?
I can address that. I don't believe that it is drafted exclusively to unlawful detainers. I believe it includes the other cases, but unlawful detainer squatter cases are included in the bill. Yes.
Can you remind me if the extension, that, you know, the notice, the extended notice provisions that we put in last year, do those apply to THOs?
The 10-day notice?
Yeah.
No, but we did extend the THO notice. So we extended the time that a landlord has to provide to a tenant before, to let them know that the lease is going to end.
Got
We
it.
did extend that.
What was that? What did we do that? It was 30 days?
I think it's 30 days on a year tenancy.
That's right. That's
Yeah,
right.
so it would be, it went from 60 days on a year tenancy to 90 days. So you get 90 days before the lease ends, and then you get the extra time between the filing and the court hearing.
Got it. Was that Senator Carter's bill? That's what I thought. Yeah.
Right.
Yes, it was,
Okay.
I believe
Yeah,
so.
yeah. Got it. Okay, thank you. All right, seeing no further questions, thank you both very much. That'll conclude the hearing for Senate Bill 564. We'll now hear from Senator Lee with the last bill of the day, 592.
Okay, this is a pretty simple bill. This is SB 592 that will prevent landlords from refusing a check issued by a political subdivision on behalf of a government entity solely because it's not one of the forms of payment listed in the statute. So this is sort of like clarifying that you can receive a payment from a government entity. The Montgomery County Office of the County Executive brought the need for this legislation to my attention. They have encountered problems when landlords refuse to use this form of payment for whatever reason. The Maryland Association of Counties notes that a total of over 70,000 applications for rental assistance have been processed, with over 40,000 households having received assistance already. So this bill will just ensure that housing stability for vulnerable tenants when landlords are not accepting emergency rental assistance payments made on behalf of the tenants. I believe the opposition is largely focused on a hypothetical, tangential issue about contracting for anything beyond the payment itself. I'm very confident we can work out these concerns, as a contract with the local government is not a feature of this bill. Accepting the form of payment would be binding to a landlord as far as a rent payment goes, but does not require them to concede anything to the local government in exchange on the face of the legislative language and clear intent of this bill. For these reasons, we ask a favorable vote on 592. Any questions? Okay, thank you, Mr. Chairman.
All right, thank you very much. So we'll now start with the panel. We'll hear from Mr. DePaul Nibber, Joanna Miller, Mr. Countess, and is Andrew Rabinowitz.
Mr. Rabinowitz is over in the house.
Okay, got it. Thank you.
Thank you, Mr. Chair. Mr. Vice Chair, members of the committee, DePaul Nibber on behalf of the Maryland Association of Counties in support of SB 592. I won't reiterate some of the testimony I've already delivered with respect to emergency rental assistance, but I will note that several of our jurisdictions have reported out instances of landlords not accepting ERAP payments made on behalf of tenants to redeem a property in the middle of eviction proceedings. So this is an issue that we are hearing has happened and have documented instances of, and so we would urge a favorable report for SB 592 on these grounds. Thank you.
Thank you, Chair and members of the committee. My name is Joanna Miller, and I am the project manager for Montgomery County's COVID Rent Relief Program. I'm here representing Montgomery County government and to request your support for HB 932. This bill expands the allowable forms of payment landlords are required to accept to include government payments. It is an incredibly helpless feeling for our team and all of our staff anytime we see someone getting evicted, but especially so when a landlord refuses to accept a check that is in a tenant's hand, as has actually happened, just because it was issued by the county and not an individual person. We have unfortunately seen this happen multiple times, and we need your help to close this loophole before more landlords can exploit it. Given the amount of funds currently flowing for eviction prevention, we need to ensure that those funds are honored and accepted as payment to redeem the property. Thank you for your consideration, and thank you, Senator Lee and Delegate Stewart, for sponsoring this critical bill.
Chair Smith, members of the committee, for the last time today, I guess. This is Gregory Countess of Maryland Legal Aid. I have to tell you that over the many years that I have been involved in representing tenants, these sort of situations where a landlord has rejected a check from the government are limited, but they occur and have occurred steadily throughout the years. The reasons for that are totally inexplicable to me, and perhaps the opponents will explain. However, in 40 years of doing this, we've never received an explanation from any landlord as to why they would reject a government check. And now, with the pandemic, with more money flowing, the opportunity for landlords to do this, of course, increase. And it's absurd. I mean, when a tenant goes to government for assistance, not to become homeless, and the government has the funds and grants them those funds in order to prevent it, you know, this is a good thing, or at least most of us would think that it's a good thing. The landlord gets whole, they get their money, the tenant and their family remains housed and not exposed to all of the harm that could come to them by becoming homeless. And so for those reasons, we'd urge a favorable report on Senate Bill 592. Thank you.
Thank you very much. Mr. Countess, if I might ask you a question?
Yes, sir.
And is it all right if he answers from the seat?
Oh, can I get up? Oh, no, I'll get up. I'm sorry.
The question that I have, I think this is probably the second bill within the past couple of weeks where we've had people come in and testify about landlords not accepting some form of payment. And I'm wondering, because I thought we dealt with this with the Home Act, and that, I mean, so where are the holes? Where are these blind spots? I mean, obviously, this is one of them, but I thought we dealt with it.
So if in fact someone were to come in and to say to me, hey, look, I've got a government check, and the landlord refused to accept it, yes. And I think in my written testimony, that's what I said. What happens then at that instance is Maryland Legal Aid has to come in and we have to file some case in some court, someplace, in order to get that person to save them from becoming homeless. So, I mean, there are tools for us to use. However, the time that we use on that particular tenant seems to me to be, I don't want to say a waste because it's valuable to them, but it doesn't seem to be necessary. I mean, there are other needs that are out there, and we are sort of like a zero-sum game. I mean, we only have limited resources to be able to use. And so if we have to use that in a case of a check, they won't accept the money.
Right, I don't, and again, I think it was last week when I was talking with someone, because this issue came up last week.
Matt Hill, you were talking to him and about the issue. And
right, some judges are interpreting it differently, and I thought we were pretty clear.
Senator Sidney, I don't think that that's not what the problem is, in terms of advocates understanding that we think that that's a violation of the source of income legislation. The issue is advancing that argument in court and prevailing. And so that's something that's up to us to do. And we've done that in these. We've gotten warrants quashed.
Gotcha.
However, that's still a use of our time that we believe could be better used for other sorts of cases.
Thank you.
So I had a similar question with the Home Act, because we all worked really hard to make sure that was passed into law a couple of years ago. But is the question, so, because the source of income thing did come up, but is the issue here is that if this money comes from written issued by a political subdivision or behalf of a governmental entity, does that bind you to other terms? Does that bind you to something that you have to adhere? Is that what their argument is? Because if accepting the money is, it comes with terms that they don't necessarily want to agree with, then that's kind of the issue. And if that's the issue, then maybe there's an opt-out, there's an amendment you could draft to fix that issue, because that seems to me that that's something that could be fixed relatively easily.
All right. Mr. Chair, are you asking me?
Yeah, sure, yeah, anyone who wants to chime in.
So I don't frankly know. I have not had those points articulated. However, I would agree with you, Mr. Chair, that articulating those points, and then perhaps there could be a way to address that. But in this particular bill, all it says is the form of payment that will be accepted. One of the things I would note, I would say to you that it's not just government money cases that we've had come before us. We've had folks who have come to us who have gotten money from a church, who've gotten money from a nonprofit in order to assist them in paying their rent. And we've had landlords who have said, this is not in a form that's acceptable in the bill. I'm not taking the money. And we don't understand why, except for it's a pretext for the landlord wanting this person out. And so that's the only explanation that I have for that sort of action.
Got it. I mean, I'm looking at MHA's, their testimony. They're saying that the payment would not require the signing of a contract. So to ensure that that interpretation is accurate, they wanted a clarifying amendment, because the housing providers are entitled to enter into certain rental assistance contracts because they were able to negotiate the contractual prohibitions and requirements as good faith partners at the table with county officials and other stakeholders. So I think check their, because this is what we're likely to consider if we want to pass this bill. It'd be good to get your opinion on their proposed amendment, because it's probably something we're going to consider as we move forward.
Is it possible for me, Mr. Chair, to get access? Or to
Sure,
have-
I'll make sure you get a copy.
Thank you so much.
Excellent. Thank you very much.
And we'll get back to you.
All right, thank you. All right, with that, that'll, seeing no further questions here, that'll conclude this panel. We'll move on to the next, so to the favorable with amendments, it looks like. So we'll have Mr. Wiggins and Ms. Howard.
Thank you, Mr. Chairman, members of the committee. You articulated our amendment, I think, pretty clearly. We discussed this last week in some capacity. Remember, I held up the contracts of the different jurisdictions and all the prohibitions and requirements in the contracts. We are okay if you want to move the bill, clarifying that we have to accept the monetary instrument of the check, which would satisfy the right to redeem. Our concern comes in when we start requiring us to sign contracts, or our members to sign contracts. Admittedly, it was a little bit difficult to hear. I was sitting next to the air purifier, but I think that was the intent, is what the sponsor said. I don't want to put words in her mouth, but I think that's what it was. And so if that is the intent, I think our amendment just clarifies that. And so I'd be happy to take any questions.
One quick question.
Yes.
One quick question. So, with respect to the bill, I mean, I understand willing to take any form. I thought the issue that you had was depending on the form, how long actual payment takes. Has
Yeah,
has that,
there's an issue there too.
okay, I
So
just
what-
wanted to know if that
what- yeah,
had been
what this bill,
resolved.
what this bill, and we, I just talked about the delays. What this bill is doing, as I read it, is it's saying that if a tenant shows up with a check from the government, with like a rental assistance check, then you would have to accept it as a payment of right to redemption. What we're simply saying is that we will accept the monetary instrument. We're willing to have that conversation, absolutely. But we do not want to be forced to sign contracts, which we've been negotiating contracts in good faith as partners at the table with the counties throughout the entire pandemic. That's why you've seen a high participation rate among landlords. I believe the gentleman from Mako last week described it as a handful of landlords they've seen, like a handful say no. And so, which I think is really a testament to the landlords in this state. But I would just point out that, our clarifying amendment is just that we don't have to sign contracts, which if that's the intent, I think we can come to an agreement there.
So everybody's good with alternative forms of payment. What you're not good with is somebody saying a payment is coming, here's the form, and we're unclear of how long that'll take.
So that's a bit of a different issue, yes. So I think if the check is ready.
Right, of course
yes,
you're going to take it.
Yeah, I think,
Okay.
yeah.
Okay, thanks.
So the issue, and I understand where you're coming from, but the issue around the acceptance of government money, and we're talking federal money, is that strings are attached to that federal money, right? And so you landlords can't accept that money from the ERAP program, for example, and then turn around and evict someone, right? So that is part of the contracts that, in my understanding, is that, for example, from the STEP program in Baltimore County and other jurisdictions, is that, and that it's part of the federal strings that come along.
That is not a federal string. That's a state string. So that is a string implemented at the state and local level. That is not a federal string.
No federal requirement that you not,
Kathy, are you aware of more?
that there's no period of time that you, for which you can't, that was totally DHCD policy?
My understanding is that, not necessarily DHCD policy, because there is no state agreement, remember, but it's like a local policy. And that's why they differ. The numbers differ depending on what jurisdiction you're in for the no filing for period. That's not a federal requirement, is my understanding.
Okay, I'd like to check that, because I thought that because part of the problem is, I mean, one of the issues is you have this enormous amount of money coming into the state, and here we are, and this is a good thing, making landlords whole, but at the same time, we don't want to make landlords whole and then have them say, okay, I'm paid, now you're out tomorrow, right? That was part of the work group. I mean, that was something that we worked on to make sure it didn't happen. And so I know that it's a state policy, but I thought it was also federal.
I don't think it is. We'll double check. I'm happy to double check.
We can check.
Yeah,
But,
but I want to note that there's no requirement. So if you required us to sign a contract with a forward no file period, there's no limitation on what the counties can make that. And I know just from previous discussions that the proponents of the bill, some of those organizations, have asked for it to be much longer than it is right now. And so that's a distinction, I think, between the federal and the state requirement.
Okay. I would hate for us to go down that route I mean, I have heard what's happening in Montgomery County, and it seems wacky to me. But I also think that we want to make sure that that doesn't happen. These are protections, I think, that are important to keep in place. So if there's
There is no statewide policy.
Correct.
Yeah,
Well-
so we've entertained that, but I'm saying, but no, so I mean, just for markets though, I mean, it's hard to, I understand that like for 24 different jurisdictions, it's like, there are 24 different rules and it can slide and that's not fair either. But I think
Right.
what we need to address is a statewide policy
Right.
to make it uniform. I mean, that's a policy decision that
And I
the
think-
assembly would have to make.
I mean, Chris, I don't know if you, it's my understanding that DHCD kind of put this out to the locals. So we actually have a meeting Monday,
Yeah,
so we can get that
awesome.
clarified.
Yeah, yeah.
Yeah, but there is no there's no DHCD, best practice document or grant agreement or something like that, to my knowledge.
Because it just deals with, okay, of course, I think this bill is fine, just the way it is, because we're just dealing with a form of payment, that where the payment comes from is, the payment is still there. And you mentioned that there were all these cases, can you give me the cases where these landlords have been forced to sign contracts as you?
No, I'm saying, I think we're trying to make sure that the bill doesn't require that. Doesn't require, because currently.
Well, is there situations where landlords, when they were given money or offer to give money by the county entity, that they were told by the county they got to sign another contract on different terms?
Yeah, I mean, to my knowledge, you have to sign the contract to get the money.
Right, you do have to sign a contract, and it varies from jurisdiction to jurisdiction, what the terms of those
Is that
contracts.
what
and
Delegate
program to
Hedelman was
program
speaking
offer.
of?
I'm sorry?
Is that the issue that Delegate Hedelman was speaking, Delegate Hedelman?
Senator Hedelman
Senator Hedelman?
is,
that
yeah.
what- I'm sorry, you were promoted years ago.
She was a fantastic delegate, but an even
Yeah.
better senator.
Excuse me, my apologies, Senator Hedelman. Would you be amenable to getting together with all the stakeholders and we can just work this out?
Sure, yeah,
We can
absolutely. I mean,
avoid any
it's just a,
injustices or any of unnecessary evictions.
Right.
Because the money is there, as Senator Hedelman said, there's all this federal money coming in. And it would just be immoral not to be able to avoid these unnecessary evictions and make people homeless simply because you didn't want to accept money from a county entity.
right, and I think, I just want to make the distinctions clear. We're not talking about the monetary instrument, we're talking about the contract. I think, yes, we'd be happy to talk about it, and 'cause I think we're just trying to clarify that.
Okay, maybe we can do this as soon as possible. Okay, thank you.
Help is on the way. We'll get there. All right. Further questions? Excellent. So with that, that'll end the testimony and the hearing for Senate Bill 529. What? Oh, Ms. Howard, sorry. My apologies.
I was going to say, me too, and we're happy to work with you. You heard my 2 cents.
Got it. Mr. Wiggins, you're becoming a really effective advocate in this committee, so good on you. You're
If not effective, at least busy.
There you go. It's good to be both. All right, and before we gavel out today, I wanted to make a little kind of cool thing, a little announcement. So absent how you feel, setting aside how you feel on the merits of the issue, it's a pretty significant accomplishment. So today in the Daily Record recently, there's a title, Federal Judge Tosses Baltimore County Redistricting Map Challenge tosses out that map under the Voting Rights Act. Baltimore County's redistricting plan likely violates the Voting Rights Act and must be replaced with a new map that offers black voters greater representation, a federal judge ruled lately. The reason why this is significant is because one of our members, Senator Sidnor, led the charge here, and you're a handsome man. That's a great photo on the top there. But U.S. Judge Lydia Gigsby granted the preliminary injunction request for several voting rights groups, including Baltimore City NAACP, League of Women Voters, Baltimore County, and Common Cause. State Senator Charles Sidnor, Democrat, Baltimore County, and 6 black voters are also named as plaintiffs in the lawsuit. So congratulations, it's significant. It's good stuff. There you go. All right, with that, that'll end the hearings for the night. We'll see you all tomorrow morning.